Hi, Commissioner Wood, are you there? Are you ready?
Yeah, I'm here and ready.
All right, good morning, everyone. It's Thursday, August 17th, 2023, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Contreras, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Madich?
Here. Well, good morning, everyone. Let me begin with one update. Good update for us. We're pleased to announce that we've hired a new Chief of Enforcement to begin August 28th. That's James Lindsay. James comes to us from the Children and Families Commission, where he was Chief Counsel previously. So welcome, James. Look forward to working with you and getting started on August 28th. All right, moving right along to item number 1, public comment for items not on today's agenda. Do we have any public comment under item 1? Hearing and seeing none, we'll proceed to item 2, approval of the June 2023 Commission hearing minutes. Do any commissioners have edits or comments for the minutes?
Move to approve.
I will second. Do we have any public comment on item 2? Hearing and seeing none. Ms. Contreras?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madich?
Aye.
Motion passes.
We'll proceed next to our consent calendar, and today that is items 3 through 7. Do any commissioners wish to pull an item from consent for separate discussion? Commissioner Wood?
Yeah, I'd like to pull item 7. I have a question about it.
All right, thank you. Commissioner
I
Baker?
would pull item 6, please. Thank you.
Commissioner Wilson?
No.
Anything? All right. So the remaining consent calendar then for today is items 3, 4, and 5. Do any commissioners have questions or comments on the items on the consent calendar?
Move to approve items 3, 4, and 5.
I will second. Is there any public comment on the consent calendar? Ms. Contreras, please call the roll.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madich?
Aye.
Motion passes.
All right. We'll now proceed to item number 6 in the matter of ACLU of Northern California, FPPC number 181511. And joining us this morning is Acting Chief of Enforcement, Chris Burton. Good morning.
Good morning, Chair and Commissioners.
Mr. Burton, do you have any opening comments or remarks on item 6?
I do not have any comments. I'm happy to answer whatever questions you might have.
All right. Commissioner Baker, you pulled the item. Would you like to begin?
Thank you. I appreciate that. I have a few questions. One is, and I probably should have just notified you in advance because it's a minor point. There might be a tiny, tiny typo on page 4, line 23, at the very end of the sentence, in an election, but which is not made to or at the best of the affected candidate. It might be at the behest. I may be wrong, but that's line 23 towards the end of the line. Apologize for bringing that up here instead of in advance. I usually try to do that. But I have a more substantive question, and it has to do with, first, the statement that there were no comparables. This is stated on page 9, or no recently considered case with similar facts. Can you elaborate more? As a commissioner, I'd be a little surprised if there weren't some in our background by recently considered, because this isn't something that hasn't happened before, I imagine. So I wanted to see if you could say more about what comparables there are or are not.
Sure, I appreciate your question. It is unique where we are not able to find a comparable case. Here, we did look to see if there was anything, but we were not able to find anything that was directly on point. There are comparables that relate to the specific violation types. So, failure to disclose advertisement disclaimers and then the campaign reporting violations. But as to this unique set of facts, we were not able to find a comparable case that we thought would be helpful in making our determination of the appropriate fine.
Thank you. And by facts, I'm thinking, or comparables, I'm thinking also of situations where you're testing if a message was basically advocating for voting for or against someone or taking a position on a ballot versus educational. Because I feel like in the almost 3 years now I've been on the commission, and particularly early on, we did deal with that question. Perhaps it's not the same statute, but is it the same analysis that would be applicable here?
You might be referring to public mailer cases, perhaps, because I know the commission has considered some of those in recent years. But here, where we have an entity that is not a governmental entity, it's a nonprofit advocacy organization. We thought that was distinguishable as well as the law. There is a different standard applied to public mailers, and so we did not think that there was a good comparable to use here. However, we do have 7 other criteria that we consider when trying to assess a proper penalty, and so we just lean more on those criteria for this case.
I think I was expecting that the analysis, perhaps it is in the public funding of political messages, which is a big no-no that we've been vocal about on the commission, is a similar analysis in terms of you're looking at the message to see if it is educational versus much more specific. Perhaps that's why, as I was reading this, I thought I might see that a little bit more. That addresses that. My other primary question was the amount of time, because it doesn't look like there's a legal question here, and the facts under the 4 corners, it doesn't look like the facts were particularly in dispute, other than ACLU said, this isn't a political message, this is a informational message. Can you comment on the amount of time a case like this took and perhaps what led it to that? And I'll say why. It's not so whether or not I support the stipulation. It is really understanding after we've adopted the guidelines we adopted earlier this year on how we may prioritize and handle cases. I'm curious how this is such an old case.
Sure. That's a great question. This is an old case. And, as we've discussed during prior updates, we do have older cases that have been delayed for various reasons, including staff turnover, which I believe impacted this particular case. But given the policy directives, we are moving through those cases more quickly and efficiently. But at the same time, we're meeting the direction of the commission, which is to continue to bring to you cases that, although old, do carry a higher level of public harm. And we felt that this was one of those cases that we did want to present to you and we thought was appropriate to present to you as a main line. But in terms of the delay, I think it really is just some of the things we've discussed in the past, including staff turnover. And this one also, I think, did require a bit of a deeper legal analysis because of needing to apply the unambiguously urges standard. It was not as straightforward as perhaps another advertising case where you have a candidate-controlled committee who sends out a mailer and they don't have paid for by. That's something that is pretty straightforward. This one did require a bit of a deeper analysis, and so I think that accounts for a bit of the delay as well.
I appreciate that, and it's easy for me to go back and say, well, this should have gone faster, but certainly under the guidelines we have, just for what feedback it's worth, this would be a case I would imagine that would in the future not take 5 years, perhaps even with staff turnover. I don't know the details of that, so I can understand how in any organization that can throw things, but given the facts were not particularly in dispute, it doesn't look like there's a lot of complexity in terms of number of witnesses and otherwise. Hopefully this will be one that in the future is able to resolve more quickly. So thank you. Those are my questions.
Sure.
Thank you. Let me just say that I am prepared to support the stipulation. I think that the fine amount is fine. I think the determination that this mailer crossed the line is unquestionably correct. I think my comments to you mirror what Commissioner Baker just said, which is it's very unsatisfying, the timeline that this proceeded on. And let me just say, this could have been an example of the things we should be doing and that we do oftentimes do well, which is identify a missing disclaimer or non-compliance before an election at the time when it is most critical to get that information to the voters. We did that here, but we didn't move quickly. And to Commissioner Baker's point, a legal analysis might be complicated, but the truth is, you can present that to a court, you can present that to an ALJ pretty quickly. It is not a case where you have to marshal a bunch of witnesses and have a prolonged trial. This was one where I would have expected us to initiate contact to request compliance, and if compliance wasn't forthcoming before the election, you would go get an injunction and force them to do it. That's what my expectation would be. And I know you can do that because you have done that before for us, Mr. Burton. Like, you're good at that. So I think in the future, I appreciate we may have staff turnover, we may have various things, but from the standpoint of the public, on balance, I don't think the public should have to wait 5 years for satisfaction on this because we can't figure out staffing. I think we can't do that going forward. So I'm just
I appreciate your
saying that.
comments. You're right, we do try to prioritize things in the pre-election posture. I did check, this case actually, the complaint actually did open after the election. But yes, if something were to come through before the election of this nature today, certainly going forward, we will be prioritizing it.
Yeah, I appreciate that. Any other commissioner comments on item 6? All right. With that, is there any public comment on item 6?
Yes, there's public comment.
Please proceed.
Yes. We have been unable to make public comments at the opening of the meeting. We were completely blocked out. We were blocked out for the first items of business. And then there's no phone number to call that responds when you have a problem. Can you hear me?
Yes, we can hear you. We're on item 6 now. Do you have public comment on item 6? If you do not, then
No,
as soon as we're done
because
with item 6, we will go back to item 1.
You blocked us off completely. We were prohibited, prevented from making public comments during the public comment period.
It sounds like there was a
Completely.
technical error, and I'm sorry for that. Our assistant is assuring us the line is open.
There's no phone number to call for help to get things like that resolved. So you just blocked the public. Do I have to file a complaint with the DA's office to get some relief?
Sir, as I
There was no
explained,
comment. We couldn't make comments on any of the items up till now.
it appears we had a technical problem. We are proceeding with item 6. We will come back to item 1 as soon as we conclude item 6. Please stand by.
So
Thank
you'll
you.
come back to public. You'll come back to public comment.
That's correct. As soon as we're done with this, we're about to vote on this, we'll come right back to public comment.
That's good. Thank you.
Thank you. You're welcome. Thank you. All right. I'm going to move approval of item 6. Do I have a second?
Second.
Ms. Contreras.
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
All right, thank you. We'll now go back to item 1 for public comment on items not on today's agenda. Do we have any public comment under item 1? And can we confirm that the line is open?
I have public comment.
All right, let's go ahead and proceed with public comment.
I'll let the other gentleman go first since he called in. I will be silent,
Yes.
but waiting.
Yeah.
Go ahead.
Yes, my name
Thank you.
is Bill Helvig, and I have a request that case number 2018-01194 be looked at. It was filed back in October 29th, 2018. It was dealing with a $320,000 advertisement for a local election, which was way out of line. I believe the investigation is done. It's been in the lawyer's office for probably 8-9 months now, and it's about ready to reach its 5-year expiration point. And I appreciate the fact that you guys are short-staffed and everything, and I heard Commissioner Baker just talk about item 6 and looking for timely resolution on these things, and I'm hoping that this gets resolved before it expires and nothing is done about it, because we feel that it was a violation, a serious violation of local practices. So, thank you.
All right, thank you. And Mr. Burton, did you note that case number to take a look at?
I did. We will certainly look into that case as soon as possible. Thank you.
Thank you. Any further public comment under item 1?
Yes.
This is Steve. Go ahead.
Oh. This is Hank Kresak, San Simeon resident, and I wanted to thank the FPPC for its efforts last year. working with the SLO County DA's office. The FPPC addressed the making of the Grace contract with San Simeon Community Service District as a conflict of interest, Section 1090 violation. The SLO DA's office continued on to show that the initial Grace agreement to the present amended contract was a violation of a total violation of conflict of interest laws, undermining public trust in their officials. The settlement agreement was reached in June of this year with the DA's office. The fines were substantial and are effectively ending Grace's business with San Simeon CSD. And interim, we have a new board majority as of November. An interim general manager has been appointed to replace Grace, and the district is in the final phases of selecting a company to replace Grace's company's operation of the district's water and wastewater. So we want to thank you for that. I wanted to give you some follow-up after all the effort you put in, that things are really changing here for the better. To finish that off, there are a number of open complaints related to the district and its operation. And I'm hoping that we will find some time to address those so our community can have a complete fresh start. And again, thank you for the FPPC's efforts.
Thank you. Do we have any additional public comment under item 1?
Yes, this is Steve Petzold in Santa Clarita, California.
Good morning, Mr. Petzold.
Hello. Well, thank you for coming back to this item. I was part of that technical difficulty, and I think you handled it very well. I wasn't aware until listening to public comment that the statute of limitations seems to run even while the complaint is being investigated. I too have a case which has been open since 2018, and I would like to see a speedy resolution of that one also. But anyway, the primary reason for calling is on the statement of economic interest, Form 700. I don't understand, and I would hope you'd have a staff address, why income from federal, state, or local agencies does not have to be disclosed. If you work for a private company, it has to be disclosed. If you're self-employed, it needs to be disclosed. And it's just hard to find out, whether somebody is actually employed with a local agency. So I don't see a reason for the differential treatment between being employed with a local government agency. Many people who work for local government agencies and serve on a board have opportunities to vote on items which involve the other local agency for which they may be employed. So all I'm asking for you to do is ask a staff member there to, why is there differential treatment on the economic form 700 as to whether somebody works for a state or government agency? I'll leave it at that.
Thank you, Mr. Petzold. I'm going to turn it over to our General Counsel, Mr. Bainbridge. I think he may have an answer.
Yeah, it's a pretty simple answer. It's what the statute requires to be disclosed on the form. So we create the forms based on what the statute requires, and it doesn't require disclosure of government income.
So, Mr. Petzold, I think in the past you've identified some other areas as well. This is one that would require a statutory change for us to change our approach to the Form 700.
Well, thank you very much for the answer. You have a good day.
All right, thank you, sir. Any further public comment under item 1? All right, well, I'm going to take this opportunity because I know we've talked about some of the older cases in enforcement. I just wanted to point out that if you look at our executive staff report, we actually have the quarterly caseload summary. And so although it is historically been a source of frustration, I want to point out that our staff since September of last year has almost halved the number of 2018 cases. And now we have no pending 2016 cases. We're down to just 2 in 2017. So I do feel like in fairness, staff's efforts to reduce those older cases should be recognized as well. So we'll go ahead and proceed now to item 7, though. That was the second item. I think Commissioner Wood, you asked for item 7.
That's right. So, excuse me. So in this item, this is a lobbyist who gave $250 to a candidate, and we brought 2 counts, one against the lobbyist for making the contribution and one against the candidate for accepting it. But there's this additional violation in there that we use only as an aggravating factor, which is that he should have also put it on his Form 615 to disclose, I guess, that he spent this money, or that he made this contribution, which he was not supposed to make based on a training, or well, based on the rules, but like that he knew from a training 8 months prior. And so I'm wondering, like, that seems to me to be a public harm, that he didn't put this in his Form 615. And it seems to be the most intentional problem here, right? That like, he may not have known that he wasn't supposed to make the contribution, that it was clear in the instructions on the form that he should have disclosed that he made it. And so the fact that we're using that as an aggravating factor rather than charging it gives me some concern, because I worry that this case will be used as a comparable later. And that's an informational harm on the public. And so I just wanted to talk about, I just wanted to hear Mr. Burton's reaction to this and see what the commission thought about it as well.
All right. Thanks, Commissioner Wood. Mr. Burton?
Commissioner Wood, I think that's a very good point that you've made there. We do look to drop combined counts where we think it's appropriate, and any mainline stipulation in the interest of negotiating a settlement. And here, when we looked at the prior comp, the way we had charged it was the violation of the ban on contributions. But with your commentary and instruction, this is certainly something that we can consider in the future in terms of looking more closely at actually charging the non-reporting violation as well. I certainly appreciate and understand your comments.
Can I ask a follow-up?
Sorry. Yeah.
Sorry, I just want to ask him to clarify something. And so in terms of the comparables, when you identify comps, are you saying that you're also going to look at how you negotiated aggravating, mitigating for purposes of what you charge as part of the comps? I think we've always kind of focused on the comps of the dollar range, right? And what we consider to be serious versus not as serious. Whereas what you choose to charge in a particular case and what you choose to identify as aggravating or mitigating seems to be more of a case-by-case, very fact-dependent determination. So I just want to understand kind of the parameters of how you use the comps.
Sure, I do think the comps can be helpful in terms of looking at what we've decided to charge versus not charge, and simply include an aggravation in terms of showing us what the public harm sort of dichotomy has been in the past. And so Commissioner Wood makes a good point. If we were to look at this comp in the future, we might see that, yes, we charged the violation of the ban, but also included the reporting violation, but only as aggravation. We might look to that. So, but with commissioner instruction, and direction, that's something else that we obviously consider. So if we were to get that direction today going forward, we would certainly lean on that in the future.
Sorry, Commissioner Wood, I just want to clarify that.
Sorry, yeah. No, I'm on a delay here, and so I know that it's hard for me to kind of be in real-time communication with you, and I'm sorry about that. So I had a little chaos in here. I just want to confirm that the prior case that we used, Carney, that didn't mention a disclosure violation at all, or a reporting violation. And the way you just talked about it, Mr. Burton, it sounded like it was probably there, but it was just folded in. But I'm curious as to whether there was a reporting violation in that case, or whether we know that there was, because it wasn't even mentioned. In which case, maybe this is a comparable for some aspects of what happened, but not for others.
Yeah, I'm just taking a quick look to see if I can answer that question for you on the comparable. I don't believe that was necessarily mentioned in that prior comparable either way. But again, going forward, if the commission would like for us to charge the reporting violation going forward, in terms of looking at this comp and how we address cases that are similar in the future, we will certainly look at that and consider that.
I mean, I would not object to giving an instruction like that, that we need the reporting requirements to be something that don't just get folded in. But, I would say that. So I'm curious to hear the other commissioners' reflections on that.
Well, two things. One, I think from kind of the big picture standpoint, I don't think that I would feel comfortable giving direction that you always have to charge a reporting violation. You can never just use it for aggravating or mitigating. To me, it's so fact dependent from case to case. I think you charged correctly what was like arguably the most egregious violation here, which is a prohibited contribution by a lobbyist. So I'm actually comfortable with the way you arranged the counts here, and I'm comfortable with the reporting violation kind of falling away in this case. But that gets to my second point, which is because in this case, my honest takeaway from this was somebody who hadn't previously been a lobbyist in California. They came here for the first time. They registered. They probably didn't pay very close attention. I think we can take that away from the STIP during their training. And they made one $250 contribution when they could have maxed out at thousands of dollars, and they gave it to only one person. This wasn't there's nothing here to show that this was some intentional scheme or conspiracy. This is somebody who should have paid closer attention. And it's actually, my initial response is, why isn't this streamlined? This is one $250 contribution that we're talking about. So I separately think this is something that I would have preferred not even end up as a main line for us, because it's one of our most, if not our most senior attorney, burning 2.5, 3 years of their time for one $250 contribution. And I just think I have to believe that our resources could be better allocated. So in this case, I'm comfortable with the charging, and I don't favor giving some blanket direction to staff on charging. That's just my 2 cents on it. Do other commissioners have thoughts?
I do. Commissioner Wood is done.
Yeah.
Thank you. I was going to get to that similar point that the chair made, but I want to echo it, that I noticed that it's 3-year case. It's a senior commission counsel on a matter that had a $250, which is $250 is a lot of money for me. It's a small amount in the scheme of what the possibility could have been. And there's not many contributions. There doesn't appear to be a fact dispute. There's a finite set of witnesses and not a legal question. So I was going to ask, similar to item number 6, do you have some thoughts on why this one would have been assigned to a senior counsel and a 3-year case? And I ask less for getting in the weeds on the job of the enforcement. It really is, I'm so mindful of what we adopted in January, which is this is exactly the kind of case I would anticipate, if it doesn't qualify for streamline, gets no attention from a senior person and only takes a small amount of time for a less experienced or more junior enforcement counsel. Is there any feedback you can give us on why the 3-year and such a straightforward case was assigned at a more senior level? And then I have a couple of questions about the details of the stipulation. Thank you.
Sure. On your first question, we do try to tailor our case assignments to our various attorneys, given their level of experience. So we do certainly do that going forward. Sometimes a case may appear to be something at the outset, but shift into maybe something more straightforward. Sometimes we might look to transfer that to a junior attorney, but sometimes it might just stay with the senior attorney just because there's momentum going and they're ingrained in the details of the case. So we kind of see different types of cases ultimately resolved by different types of attorneys, but yes, it certainly is our mission to give senior attorneys the more complicated cases that we see, given the particular violations that are at issue.
And the 3-year perspective, given this looks like a negligence and mistake and a fairly, one contribution, maybe 1 or 2, maybe a handful of relevant witnesses. Any thoughts on what may have done that? I realize there's a pandemic that did happen in 2020, but we're quite a ways out of that.
I can tell you in this case in particular that it was impacted by staff turnover and also an extended leave of absence.
Thank you. My questions, originally as I looked at this, I'll ask a fact question first. On page 4, line 6, there is an acknowledgement from Addis that she did solicit the contribution. I don't know if you're able to say, did it come across as soliciting the contribution from the lobbyist or from the lobbyist client with whom she met? Because it's not uncommon for a candidate to solicit a contribution from someone through their lobbyist, and then the contribution comes from let's say the entity, the client, which in this case might have been completely appropriate. Are you able to say more about that? It's mentioned in the Four Corners.
I don't know where, but I believe in the STIP elsewhere, it does clarify that she solicited both the lobbyist and his client.
Excuse me, that might be my remedial reading, so I appreciate that. That's helpful because I was kind of thinking about Addis's level of wrongdoing on this. And to the chair's question about streamline, and this may be more a question for Mr. Bainbridge, but my understanding is that our executive director has discretion to take a case out of streamline. Do they have discretion to put a case into streamline? Because this otherwise would have been a candidate in my mind. I don't know if it's completely prohibited. Do you know the answer? Who can address that one?
I can just quickly say from enforcement's perspective, we typically would not use discretion to include a case in streamline where the violation type is not already included in streamline. If general counsel or someone else would like to speak to that as well.
Yeah, no, he's correct. If it's not mentioned in the regulation for streamline, you can't add a violation that's not included in the regulation to the streamline process. And just to clarify, it's the chief of enforcement who approves the streamline stipulations.
Gotcha. Thank you for that.
So it is, just to put a fine point, you said we wouldn't typically, you're actually prohibited from doing it. You can't.
Yes.
Okay.
Yes.
Helpful to know.
We're all on
'cause-
the same page.
Thank you. And, because we were identifying that, boy, this, in our minds, may have been, so many other elements of this would have been a candidate for streamline. I don't want to spend much more time on it. As I read this, I actually, until I heard Commissioner Wood, I thought that the fine was disproportionate to both the harm as well as the fact pattern of one contribution. It's replete throughout this that this was negligent, frankly, primarily on the registered lobbyist. And I had some issues about whether or not I might support something that was such a dramatic, I thought was a disproportionate fine, given that there's a bigger harm that happened here that was an aggravating circumstance. That might get me there. My question about that one is, had that been charged, the Form 615 issue, that would only have been a violation of the lobbyist, not something jointly and severally liable for the candidate. Is that correct?
That's correct. That would be the lobbyist's responsibility.
And, this candidate's going to be paying for this for a long time beyond this. This will always be used against her that, you got fined by the FPPC to a multiple percentage higher than the actual contribution from taking money from a lobbyist. I guarantee you the Oppo research is always going to hit them with that. I would this one commissioner's feedback is, again, this is the type of case that I would hope would go much faster given the lack of complexity. And this is the outer bounds of what I would consider a proportionate fine. If you'd like to weigh in on the proportionality of it, I'd love to hear it.
I do think this case is arguably close to the line because it's not a violation type included in streamline. We're really looking at, is a mainline appropriate, or do we need to send a warning letter? Here, where we had a mainline comparable case that already supported it, and given some of the aggravating factors, and in particular as to the candidate and the committee, the fact that they solicited and accepted the monetary contribution, which was a different situation from the comp, we felt that that was aggravating enough to include that in the mainline as well. However, on the other side, I think maybe the lower level of public harm is addressed in the fine amount, because this is about as low as a fine as we will propose within a mainline stipulation.
So you would have had discretion, for example, to do $1,000, which is quadruple what the contribution is, but you would consider that outside of what you might do for mainline?
We typically don't go any lower than $1,000 for a mainline. And so here where you have 1,000 and then 1,500, that's really at the lower end of the spectrum for what we would charge in a main line.
Well, thank you. I appreciate it, and I guess I made my points, and I appreciate the answers.
Commissioner Wood, any further comments?
No, thank you. I agreed with everything you guys said. I am happy to move to accept this if you guys are ready for that.
Well, hang on. I want to see if Commissioner Wilson has anything.
Oh, sorry, Commissioner Wilson.
I mean, well, given the lengthy, discussion and the issues that were raised, I mean, is this something that we ought to consider whether this penalty is appropriate, or I'm not arguing that it is necessarily, but I think there's some serious questions that have been raised. So I just throw that out as, a potential issue.
Yeah, my take is that I would be interested in having in the future the legal division come back to us with some thoughts on how we might be able to refine our streamline criteria and prep. I mean, we're talking about it in terms of streamline. I actually think this is a perfect example of why prep is so important, because it's the first time registered lobbyist in California who clearly didn't pay attention the first time. So requiring them to go through prep and ensuring that if they ever do business here again, they know the rules and they're compliant with the rules. I think that's the whole purpose of prep. It would have been maybe a more satisfying outcome. So that's my sense, is that we use this as a reason to request staff to come back to us in the future. But for this particular item, I'm prepared to support the stipulation as presented by staff. But that's my 2 cents.
And it's interesting, because as I thought about this, I thought this wouldn't be appropriate for a warning letter, because it is a clear ban. Somebody just, and they didn't file their 615 in disclosure. And I'm not sure that I would have put it in prep. I certainly would have thought about streamline, so we may differ a little bit on it. I do have my own reservations about the proportionality of the fine, given where we were on this. And I had come into this not intending to support it because of the disproportionate where we are. I'll share with my colleagues that there's an aggravating factor that would have hit the lobbyist that is not charged here, and that the candidate wouldn't have been responsible for. That really, that's the person that I tend to focus more on, is the lobbyist. It's made me go back and forth on it. But I just think this is beyond the bounds of what we would normally do for something that we otherwise would have seen in Streamline.
Yeah, I mean, the other thing that I'm cognizant of is it's already an old case, and it's our most senior attorney. I'd kind of like him to move on to other things. So I'm not so offended by the amount. But let's take public comment on item 7. Is there any public comment? Hearing and seeing none. Any final commissioner comments? Going once. All right, then I'm going to move approval of item 7 as proposed by staff. Is there a second?
I can second.
All right, Ms. Contreras?
Commissioner Baker?
No.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, thank you. Thank you, Mr. Burden.
Thank you.
See
Appreciate it.
Later in the meeting. All right, let's go ahead and move to the first of our general items, and that is item 8, pre-notice discussion of proposed regulation 18318 having to do with collections. And with us will be our senior commission counsel, Karen Harrison. Good morning, Ms. Harrison.
Good morning. Well, after that nice discussion of allocation of resources, we'll segue right into allocation of resources on collections. So good morning, Karen Harrison, Senior Commission Counsel with the Legal Division. I'm presenting proposed regulation 18318 for pre-notice discussion. We will come back at a later time and present this for adoption. So just as a little bit of background and to refresh recollections, in April, staff presented a presentation on collection issues, and as a part of that presentation recommended certain actions, one of which was a regulation clarifying the executive director's ability to enter into a settlement agreement in full satisfaction of a monetary penalty order under certain circumstances. So that is the regulation that we are looking at today. Proposed Regulation 18318, in accord with state laws and state policies regarding the collection of an account receivable, that's how the state refers to it once we're at this point, account receivable by a state agency, delegates authority to the executive director to enter into a settlement agreement in full satisfaction of the order for monetary penalties where the following items are met. Number one, it needs to be a final order, no possibilities of appeal. Number two, 3 collection demand letters need to have been sent. Number 3, staff needs to have made reasonable collection efforts, and the proposed regulation defines reasonable collection efforts as, first, seeking offsets with a state agency such as the Franchise Tax Board. This means, for example, if someone were to win state lottery winnings and they had an order for monetary penalty outstanding with the commission, the state would capture that amount, and that amount would go to the general fund. All these account receivables go to the general fund. The other prong to reasonable efforts is where legally permissible, staff has obtained a court judgment or a court clerk judgment. We have 2 statutory provisions that allow us to do that, and then followed appropriate enforcement remedies under the Civil Procedure Code. These remedies are filing a real property lien, personal property lien, can also be wage garnishments and bank levies. Then that the executive director needs to determine that the settlement is appropriate considering factors, and there's 4 factors that are proposed in the regulation. One is that the settlement amount exceeds the amount likely to be collected within a reasonable time. The next is the debtor's ability to satisfy the full debt or a greater amount of debt in a reasonable time. This is considering the debtor's financial picture, their assets, their income, and their prospects for future assets or income. Next is the executive director can consider the amount of the debt that is attributable to interest on the original penalty amount. For some of our older cases, the interest amount can build up over time. And lastly, the severity and type of violation for which the penalties were assessed. Then in subdivision B, the executive director is to include a brief description of staff's reasonable collection efforts and the factors that justified the settlement agreement, and report this is language that would be placed in the settlement agreement, and then report the agreement to the commission after its execution. So that is the proposed regulation in a nutshell. Are there any questions or further direction?
I do have a question. In terms of the factors that the executive director determines in exercising their settlement authority, the first one, the settlement amount exceeds the amount likely to be collected within a reasonable time period. What are the standards or the factors that we anticipate the executive director using to make that determination?
So an important part of the process is that a skip trace is done during the time period when the demand letters are being sent. And so the executive director and staff are going to have an idea of this person's financial picture. And if they can place liens, they would place liens. And then it's a matter of how long is it going to take before this matter is final, before that's finally paid back. So that would be something to consider. And keep in mind that while it might look good that you could do a wage garnishment or a bank levy, bank levies, for example, can be very hit and miss. And so knowing how much they might be able to collect in a reasonable period of time allows the executive director to value what that settlement agreement offer might be. Does that answer your question?
It does. It gives me a sense. So it's essentially the executive director is going to take a wide view of a bunch of different factors and then make their determination, is what you're saying.
Because time is a factor. One of the mandates under the state laws governing collections of ARs by a state agency is that the state agency doesn't go after every single dollar amount. It's a cost-benefit analysis, allocating their resources to the most efficient means of collecting on the account receivable in a timely manner. And so those are all factors that are reflected here in this proposed regulation.
All right. So the executive director exercises their delegated authority to enter into this settlement, and then the commission is informed of that through the regular reports from the executive director. Presumably that allows us to monitor how her delegated authority is being exercised, and if we find problem with that, we can remedy it through subsequent changes to the regulation. Is that the idea?
Correct. Changes to the regulation and guidance, just as we've been listening to earlier in this meeting of what the commission would like to see an emphasis on, or perhaps questioning what are the reasonable collection efforts, if that's sufficient. So that's a time for feedback. Again, considering the cost-benefit analysis that the state law requires, we felt that that was the most efficient way to set up a process.
Okay, I appreciate that. All right, thank you. Those are my questions. Commissioner Wilson?
Thank you, Council Harrison. Your memo and other information outlines this in extensive detail. Are there other state agencies that have a similar process where the executive director has similar authority in terms of collections?
That is a very good question, and we are actually reaching out to other agencies and trying to get feedback on their process. We have not received that feedback yet, but we hopefully will have that in time for the next meeting, and it would be reflected in the memo that is prepared and presented with the regulation.
Yeah, I mean, for the record, I think this proposal is a good idea, but thanks for looking into that additional information as well. Thank you.
It is actually part of the state mandate that an agency look to other agencies to see if they have had successful collection methods and follow those methods. So it's part of our responsibility.
Okay, thank you. Commissioner Baker?
Thank you. Also, thank you for the clear and helpful presentation. I want to follow up on the last point that the chair made and just get a little more specific. As I read this, I thought, okay, the executive director will report to the commission, then what? And you mentioned it's similar to giving the guidance that we've given today, but in enforcement matters, we then vote on, say, a stipulation, even with the guidance. Is it anticipated that there would be a more formal, adoption or agreement, or is it just FYI, we're reporting this to you, and you can give feedback, but this is what's happening? I'm just curious which more finer point of the commission's role is after the executive director gives a report to us.
So the way the regulation is drafted right now, the feedback would be on the process, on the factors, perhaps how they were weighed, what were the considerations, and what the commission would like to see in the future. The way it's written now, the authority is delegated to the executive director to execute the settlement agreement and report it to the commission. So the feedback wouldn't be necessarily to vote on that settlement agreement. And some of that is just a time consideration, bird in the hand type of decision-making process. I'm told that this is similar to the streamline process, where decisions are delegated and made at a lower level just because that's the best use of time.
Yeah, I agree that this whole process is a very good one to see, and I'm so grateful to the staff team for raising this and reporting so thoroughly on it. I'm good with that. I just wanted to get very specific, kind of on the record now, that that's what's anticipated. It isn't quite like an enforcement matter where we're approving a settlement agreement. We're giving that authority to the executive director to approve it, but to report to us and seek any feedback at that time. That's what I'm hearing. So thank you.
And one of the things I would just comment on, I neglected to mention it earlier, these collection matters, as we saw in the April presentation, are primarily default judgments where there's been no participation. And then 3 demand letters have been sent and there's been no participation, no response. So if a settlement agreement were to come together, I believe time would be of the essence.
Thank you.
Any other questions for Ms. Harrison? Commissioner Wood, anything? All right, is there any public comment on item 8? Hearing and seeing none. Thank you, Ms. Harrison. We will see you in October.
In Fresno.
All right, thank you. In Fresno, that's right. All right, moving right along, we'll proceed then to item 9. This is our second pre-notice discussion. This subject is refunding contributions after withdrawal from a primary election and disposition of contributions after election in a primary election. With us presenting on this is Senior Commission Counsel Zachary Norton. Good morning, Mr. Norton.
Good morning, Chair and Commissioners. All right. Today's pre-notice discussion involves amendment to Regulation 18531.2 and Regulation 18537.1. This agenda item concerns two distinct issues, both of which address the disposition of campaign funds when a candidate does not run an election. For pre-notice discussion, staff presents amendments to two regulations addressing these two distinct and relatively uncommon scenarios. Issue 1 concerns refunding contributions when a candidate chooses to withdraw from the primary election, which is currently the subject of two conflicting advice letters explaining what a candidate must do with remaining campaign funds for the general election after withdrawal from a primary election. And issue 2 concerns the disposition of general election contributions when a candidate receives a majority of the votes cast for office at the primary election so that the candidate is elected to the office without advancing to the general election. We begin with issue 1. So in the Kaufman advice letter, a 2006 candidate for state treasurer decided not to run in 2006 and opted to run for state treasurer in 2010. He opened a committee in connection with the 2010 election and sought to transfer funds raised in connection with the 2006 general election to the 2010 committee. The letter concluded that withdrawal from the primary election effectuated a withdrawal from the general election for that office, and that funds raised for the general election to that office must be returned to contributors consistent with 85318. In the Brown advice letter, a candidate sought to transfer contributions raised for the 2010 general election for the office of Attorney General to his committee for the 2010 election for the office of Governor. And this letter concluded that Section 85318's requirement to return general election contributions applies only after the candidate has either been defeated in the primary or has won the primary, but subsequently withdraws from the general election. Staff recommends adopting the approach from the Kaufman letter because it would apply Section 85318 to create consistency among very similar scenarios. The existing rule requiring the refund of contributions for defeat in the primary election or withdrawal from the general election should also apply to withdrawal from the primary election. Further, this approach is consistent with contribution limits and the notion that contributors provide contributions for use in an election to a particular office and reduces incumbent advantage. Section 85318 states that when a candidate is defeated in the primary election or withdraws from the general election funds must be returned to contributors. Section 85318 and existing regulations do not address refunding contributions when a candidate chooses to withdraw from the primary election. And since winning the primary election is a prerequisite to appear on the ballot in the general election, a candidate's withdrawal from the primary election also effectuates withdrawal from the general election for that office. Staff recommends adding a provision to the regulation explicitly treating withdrawal from the primary election in the same manner as a defeat in the primary election. And the three options presented today only differ with respect to issue 2, which we will discuss next. The proposed amendments related to a candidate withdrawing from the primary election are the same for each option. With that, I'm proposing to take an intermission to respond to any questions before we move on to the next item.
So with respect to issue 1,
Yes.
we have staff has identified a conflict between two advice letters.
Yes.
And the conflict is in how we're interpreting Government Code 85318.
Yes.
And what staff is proposing is that we interpret, and tell me if I'm right about this.
Okay.
85318, the term withdrawal, to embrace the scenario in which a candidate does not run in the primary because we are saying that legally you are no longer qualified, if you don't run the primary, to be a candidate in the general election, and that constitutes a withdrawal. Is that what you're?
Yes.
Okay. I just wanted to make sure I
Okay.
kind of was following along with
Yes.
like the legal reasoning that gets us to why the Kaufman advice letter is staff's preferred approach to interpreting 85318. So that's a correct understanding?
Yes, that is correct.
Okay. All right. I just wanted to clarify that. Yeah. Commissioner Baker?
Thank you. And I appreciate that. You actually addressed one of my first questions after reading the memo, where memo says staff believes the conclusion of Kaufman advice was correct, doesn't elaborate more on why. And you have a bit, you've mentioned that because you think it's more consistent with the language of the statute. I'm going to flip that a little bit more so I can really get to embracing the recommendation, and that is, what's wrong about the Brown letter? Why was Brown inconsistent?
We just don't think Brown is as consistent with the requirements of 85318. It doesn't seem logical that under some circumstances you would need to refund the contribution, and under this other sort of unique set of circumstances you would not. Okay.
Thank you.
Sorry. Commissioner Wood, did you have any comments or questions?
Yeah, I guess in Kaufman, the person ran for the same seat but later. And in Brown, he obviously withdrew from one campaign and decided to try for a different seat, basically, a different office. And so I'm wondering if that distinction matters at all. I don't think it does for what we're talking about for this set of facts, but I just wanted to hear whether you guys even talked about that, because to me it stuck out. Like, so, you know, what's the donor intent here? Is the donor intent to support the candidate no matter the office? Or is it to support the candidate getting that particular office no matter the time? Or is it only to support the candidate getting that office in that time? That's really tough, you know?
That is, and that is something I thought about. I thought that was maybe unusual because the facts of Brown, at least in my mind, seem to suggest that refunding the contribution would be the better approach, because I think it's hard to know the specific intent of the contributor, but I think when a candidate is running for an entirely different office, I think it sort of presumes that there is this broad intent to support the candidate no matter what. But in certain scenarios, you know, some contributors might support, let's say, a candidate running for state senate because that particular candidate would represent them. If that candidate said, well, I'm going to run for assembly, they might decide, well, I'm not in, you would be my senator, you would not be my assembly member, therefore I never had an intent to support you for that different office. So we think taking into account donor, contributor intent, refunding would be a better route to go, because I think it sort of protects that interest.
I mean, it defines the intent very narrowly, which is probably safe, but I don't know. I just want to be really analytically clear on what the assumption underlying this is, because it may matter when we go into the next issue, right? And so the Kaufman approach says same candidate, same seat. No, the Kaufman approach says you have to refund anyway, right?
Yes.
Hold on.
Even if it is the same candidate for the same seat, but it's for later. Sorry.
Hang on. We need to be very careful when we're having this discussion, because we're talking about whether you have an obligation to return the money you raised for the general election if you didn't run in the primary election, not whether you're returning all of the money.
Yes.
So I just think we need to be put a very fine point on what you're returning, when, and under what circumstances.
Yes, that is it. There are.
Well, sorry, Commissioner Wood, did you have a?
No, I'm good. I'm still like listening and learning. I found the whole thing a little more confusing than I thought I would. And so I want to hear your feedback too.
Yeah, so sort of going off of Commissioner Wood's last question, which I think really was, is it relevant for our assessment of Kaufman versus Brown, that in Brown, he transferred money for a different office as opposed to transferring it for the same office, but just a future election to the same office. And I actually think, when I look at it at least, 85318, the first sentence is specific to a scenario in which it refers to for the same elective state, county, or city office. And then it's the second sentence of that same provision, which is specific to the same office, where we get the limitation on if you don't run in the primary, you're defeated in the primary, you have to return the general election money. And so Kaufman is four square within, I think, the scope of 85318. One might argue reasonably that Brown is not, because Brown was not a situation in which it was the same office. I just point that out as an observation now that I look at the statute more closely, and I'm looking at the two advice letters. So I just wanted to make that point.
Yeah, I do think it's relevant that in one scenario, for what we're doing today, I know this is pre-notice, so we're all giving feedback, and I'm going to be eager to see how the comment period comes through, because it'll be interesting to see. But I think it is relevant that in one scenario it is to the same office, and one it is not. And that, for my purposes, will influence, what I think is consistent. The question I have for you is, and this may be the right time to ask, or maybe as you're done with the full presentation, it's also relevant to me, what was the legislative intent? The extent to which we're able to determine that, how expansive, or is there anything in the legislative intent, and perhaps you don't have that now, but when we come back for future presentation to us on this draft, I will be interested in hearing a discussion of what appears to have been the intent of the authors and how this came forward to begin with, because I think that's relevant here too. It doesn't have to be now.
Okay.
But since this is pre-notice, that's my feedback.
Well,
And
did you look at the ledge file, Mr. Norton? And do you have anything to offer now? It's fine if you don't. I'm just curious.
I think we're not clear on intent, and I can look at this more closely before our next meeting. I think this is a situation that is unusual and was not foreseen by the drafters, because it's.
Well,
Yeah, and I think it might have been an initiative, but the authors of the initiative to put it on the ballot, whatever legislative intent there was on, that is relevant here, I'll be interested in that being addressed, because it's not in the memo. I totally understand. Memo's very thorough and very good, but that's a question that I know I'm asking now, and I'll be interested in the future. It doesn't have to be answered today. I see Mr. Bainbridge has got the mic ready.
Yeah, I got the green light here. You're correct, it was a ballot measure. So typically with ballot measures, there's very little legislative intent, but we will look to see what is out there about this specific topic. It was part of Prop 34, so I think the bigger issues that caught people's attention will probably be what we'll find, and this is kind of towards the end of the section and not that interesting to anybody not listening to this meeting right now. But we'll look to see what is out there that might be instructive. We have looked to a certain extent in reviewing these letters, because they certainly would have done that research and looking at these letters as well. So.
Yeah, and I'm thinking of the scenario where the legislature put it on the ballot, and if the authors ever gave testimony either to the commission in subsequent years or to in whatever ballot statement they might have done in advocacy on what they thought, should we be expansive, should we not be expansive, should it be, what it should be is relevant to me here. So thank you.
All right. Any other questions for Mr. Norton on issue 1 before we turn him loose on issue 2? All right. Go ahead, Mr. Norton.
All right, so issue 2. So the existing laws concerning return of contributions, transfer of contributions, and carrying over of contributions do not address the circumstance where a candidate is elected to office by receiving a majority of votes in the primary election without requiring advancement to the general election. So for certain, mostly local offices, a candidate that receives a majority of votes in a primary election wins the office and does not run in the general election. Staff has identified 3 possible options for implementing existing requirements in circumstances where a general election is not required. 1 would be to permit carryover of general election funds pursuant to Section 85317. 2, permit transfer of general election funds with attribution to contributors and subject to contribution limits pursuant to Section 85306. Or 3, require return of the general election funds to contributors pursuant to Section 85318. There are 3 statutes that could apply, but it isn't clear. So today, we're asking the commission to decide which one should apply. So we'll begin with option 1. So under this option, when a candidate is elected to office without advancing to the general election, funds raised for the general election may be transferred without attribution to a committee for subsequent election to the same office. This would include these funds within the attribution exception for Section 85317 and permit a candidate elected at the primary election to carry over contributions for the general election as if the candidate had run in and won the general election. So by treating an outright win in a primary election as the equivalent of winning in a general election, this approach permits a candidate to carry over funds without attribution and therefore without regard for contribution limits. However, by allowing a transfer without regard to limits, it does undercut the purposes of limits. Option 2. So under option 2, when a candidate is elected to the office without advancing to the general election, funds raised for the general election may be transferred with attribution to a committee for subsequent election to that same office. This differs from option 1 in that contributions would not be exempt from the attribution under Section 85318, and the attribution requirements of Section 85306A would apply. This approach ensures that contributions would be attributed to specific contributors, and the applicable limits for the subsequent election would not be exceeded. And option 3. So under option 3, when a candidate is elected to office without advancing to the general election, the funds raised for the general election must be refunded under 85318. And this is consistent with other instances where a committee raises funds for an election but the candidate does not ultimately run in the election. Existing law does not allow a candidate to keep leftover money when a candidate does not run or withdraws from a general election. And this approach is consistent with Section 85318, requiring the return of contributions received for use in a general election in which the candidate did not participate. And with that, I'll open it up for any questions.
Thank you, Mr. Norton. Just so that I can keep this all clear in my own head, please.
Yes.
So the first general rule is if you transfer with attribution, and that is found in Government Code 85306A.
Yes.
There's an exception to 85306A, though, which is if you're running for the same office at a subsequent election, then you do not need to attribute. Correct?
Yes.
And by the way, as a side note, we construe exceptions narrowly as a general principle.
Yes.
And then we have 85318, which seems to create an exception to 85317's exception to the general rule. And it specifically says that if you withdraw from the primary or are defeated in the primary, you have to refund the general election money you receive. Right? So it narrows the application of 85317 in that circumstance.
Yes.
All right. What is I just want to take now, I understand kind of the order of things. We're talking about an exception to an exception that doesn't specifically address the fact pattern that has caused you to bring this to us, which is where they're not defeated in the primary, they're not withdrawing from the general, they just win outright in the primary. And it's not specifically addressed in the statute. What is our basis for taking regulatory action to fill that gap in this statute? And why shouldn't we just send this back to the legislature as something that they need to address?
Well, I think we can look to the act itself, and the act does empower, if not require, the commission to take action specifically to adopt, amend, and rescind rules and regulations to carry out the purposes and provisions of the act. So that's in 83112. So I think it does empower the commission to act when it's not clear. And I don't think in this case we would be depending on which way the commission chooses to go, I think there's arguments for going in either way. I think requiring the return, we would look to that as implementing the contribution limit requirements under Proposition 34. So there's, even though that's kind of the exception to the exception scenario you raised, while the statute itself might not be clear, I think this was not explicitly contemplated. I think it's consistent with some of the purposes of the act. And I think it's, from the point of view of the commission's authority, I think that authority it's granted in the act itself. And there's also case law that talks about the authority to adopt regulations that are consistent and not in conflict with the statute and necessary to effectuate its purposes, and that comes from the Watson versus FPPC. So it has been addressed. I think it's been addressed by statute and by courts. So.
Yeah, well, what exactly are we interpreting here? Because I think the legislature or the voters were extremely clear about very specific circumstances, and they don't mention this circumstance. So what is the language here that we're interpreting and not adding to without some basis for it? That's what I'm concerned about, is right, because they were very specific, and now we're taking a new scenario that isn't contemplated here, and we're saying, but this rule applies in that scenario. So and normally when we do that, we're interpreting some language in the statute that gives us space for regulatory interpretation. And I want to know what language we're focused on here that we're interpreting to get to where we want to go. Is it the concept of withdrawal? Are we expanding that concept to say that essentially you're withdrawing from the general by winning in the primary because you can't be a candidate in the general?
Yeah,
what is the theoretical legal hook to this statute?
I think that is a theoretical legal approach. I mean, if you are not running, I think it is equivalent to withdrawal. Now, in this case, the election is not being held, so the candidate is not running. So I think that's probably analogous to withdrawal. It isn't. Yes, it's not explained in the statute, I think partly because it's not a very common scenario. As I pointed out, it really only happens at the local level, and some jurisdictions have ordinances that provide for election to office at the primary. That doesn't happen at the state level. So.
All right, Commissioner Wilson.
Yeah, I mean, I know this is just the first time we're looking at this, but I'd like to get some feedback, not right now necessarily, about whether the FPPC, whether we have the statutory authority to implement these regulations. I mean, there's clearly difference of opinion with regard to the Brown letter versus the Kaufman letter. Every scenario could not be anticipated, but you could have a scenario where a candidate is elected, but then doesn't assume the office by taking the oath. Do we have the authority to address that issue? Probably not, but I'm concerned about to what extent we have the authority under the Act to implement, this regulation.
And I think, that goes back to, I think, the Act itself empowering the Commission to adopt regulation generally. So.
We do. We have power to generally do
Yes.
that. I'm not disagreeing with that. What I'm trying to do is feel comfortable with what in this statute specifically are we interpreting. And that's for me, that's what I need to know. I need to know that we have general authority to interpret the words in the statute. What words are we interpreting here? Because they use some very specific words that I'm sure we're not interpreting here. So what is the hook? What is it that we're interpreting here? So that's the flavor of my commentary, at least for my part. Commissioner Baker, I don't know if you have additional.
Thank you. I have the exact same question, and in fairness, that may be something you'll be coming back to us on, because a robust discussion of that is something that I think we need to have. We're having it here, but give you an opportunity to rethink that or go back and look. And in particularly, what's the statutory basis, number one, and you cited Watson versus FPPC. I'd also encourage Citizens to Save California versus FPPC, a 2006 Fourth Circuit case where the court was really talking about when we have a hook in the statute, as well as if you're restricting or expanding a right if that is within our authority. I don't have an opinion beyond that. I would just encourage you to look at that one as well, because that's what we might be doing here. If we are narrowing what is allowed to be interpreted as withdrawal, or if we're narrowing when carryover is allowed, do we have authority to do that in the statute? So I'll just encourage that. Secondly, I reiterate my question regarding legislative intent, knowing this was, I think, a legislature put Prop 34 on the ballot. But the legislative intent about carryover and attribution, if there's anything that, as you go back and look at that, helps us decide which is more analogous to our situation here. Because for me, option 3 is going too far. I feel like we would be there isn't a statutory hook for us to do just a return, because I can't get there. I'm toggling between option 1 and 2, which has a statutory hook and which is most consistent with the statute and our authority. And that's going to depend on if I see winning a primary as also effectively winning the general or as withdrawing from the general. I haven't made up my mind on that, but I think that's a little bit where I'm at. And if there's anything in the legislative history that I don't know that they would have even paid attention to this. There are probably a lot of other parts of Prop 34 that paid most attention to. That will be helpful for me to know. So my feedback, again, is a robust discussion of what's the statutory hook. Not only what are we interpreting, but are we going outside the bounds of interpreting based on all the case law that you might find relevant? And what's the legislative intent? And then my just straight up feedback, which is I'm veering away from option 3 because I really think the debate is between options 1 and 2. So thank you.
I have more, but Commissioner Wood, do you want to go first?
Sure. I mean, it's very humble of the commission to say, what's our statutory authority? What language are we interpreting? I mean, I think, I was just looking at the Political Reform Act. It says something about like, the commission may adopt, amend, and rescind rules and regulations to carry out the purposes and provisions of this title, right? So like, they don't all have to be interpretive rules. They could also just be rules that set policy, even if you can't have a really firm statutory hook aside from we're fulfilling the purposes here. And so I just, I feel like this on the federal system might be kind of reviewed with a arbitrary and capricious standard as opposed to a Chevron type standard, right? Because we might not have a firm statutory like language that we'd be specifically interpreting, but we still may be obligated to set policy to fulfill the purposes of the act for this little, filling in the details type loophole that we seem to have here. Also, just, I think I sorted out what is going on in these statutes, and maybe you guys already got there, but I'm just going to say this because I think it may be helpful for anybody else who may have felt confused, which is that 85306 says if it's the same candidate but not the same office, we require attribution. And then, oh God, I didn't write down the number. 85317 says same candidate, same office, no attribution. And then 85318 is if you lost, you refund, right? And so it actually kind of makes sense to me analytically that if you're changing offices, then you do need to go back to the donor and get attribution. But if you're running in the same office, we're going to infer donor intent for that same office. So I think that's kind of neat, actually. And it fell together for me. It all came together Tetris style in my head while Mr. Norton was talking. So anyway, I think that losing the primary doesn't seem to be the facts that we're talking about here in these kind of strange cases. So it would be between, options 1 and 2, and it seems to fit very cleanly. Like if you're going to run for a different office, then we need attribution. And if you're going to run for the same office, we might not need attribution in a subsequent election. Like it seems like analytically, this can all fit very easily to me. Anyway, so that's my feedback. Sorry to be a really aggressive regulator all of a sudden.
No, I just want to remind our colleagues that you are the one who is a professor of administrative law. And so when you talk about the scope of our authority, it's reassuring, Commissioner Wood, to hear your perspective on that.
And as a citizen of California, I'm very reassured at how much you kind of want to hesitate until we have a clear hook to be able to interpret it. But I just want to say we can do more than just interpret. That's all.
Yeah, no, I agree. I appreciate your point. I think, one thing I will just say is I actually think option 3, I'm not, initially, I'll just give you kind of the play-by-play in my mind, how it's evolved. I started out, I think, preferring option 2 because it strikes me as the most reasonable option. But it's when I went back and was looking at the statute and trying to understand what we were doing in terms of interpretive exercise here. If we're interpreting primarily in this regulation 85318 and the concept of a withdrawal from the general, so in other words, you win outright in the primary, that is legally, we're considering that a withdrawal. I actually think our only option, if that's what we're doing, is option 3, because the remedy, if you call it that, under 85318 is returning the general election contributions. You don't attribute it there. And so I think, even though I may think that's kind of draconian as an outcome in that fact pattern, I actually think if we're tying it to that statute, I would then be concerned that what we're affording is more permissive than what that statute requires. And so that's just an observation that I had. I don't know, who wants to go? Commissioner Wilson?
Mine is more Sorry about that. Thank you, Council Norton, for your detailed briefing on this issue. But as a follow-up to Commissioner Baker's recommendation about legislative intent, not to get too much into the weeds here, but you might want to consult with our legislative counsel, Council Nakano, and look at analyses that are available on these bills when they move through, through the legislature, and also to see if there's any. It's not always the case, but if there's any letters of intent in the Daily Journal in either the Assembly or the Senate when these measures were taken up. So it's just, just an idea to consider.
Commissioner, that's a good suggestion, I think.
Excellent. I am grateful for that and the chair's comments. I originally was, I'm kind of following the other way. And so I'm just sharing it with as well. On to me, if it's same office, it really tastes more like carryover. But I have the concerns as well about, what does that say about, campaign contribution limits? And again, there is appellate case law when we have dealt with these very similar questions on that. You've cited some cases. I cited one that'll be interesting to hear. There is rules of statutory construction. I'm sure that we're informally invoking, and so that's where I'm falling. I don't see, at this time, and not hearing further public comment, that winning the primary outright is the same as withdrawing. You're not making a decision to leave a race. You put, presumably, everything you could into the primary, and you won it outright. And so I'm finding it right now as more similar to also winning the general, and that's, I think, why I'm heading more towards carryover. And again, this is pre-notice. That's just the feedback that I'm coming to at this point. My mind is very open still, but hopefully we've given enough guidance on the things that we're thinking through. And that's it. You're looking at Mr. Bainbridge, so I'm going to turn my mic off.
Yeah, sorry, Commissioner Wood, hang on a second. Mr. Bainbridge has been trying to get to the mic.
Waving my hand over here. I just wanted to mention two things about what Commissioner Wood said. One is she mentioned that 85306 applies when a candidate transfers to a different office. That's not true. It's any transfer to another committee controlled by that candidate. So it could be same office or different office. And then potentially the 85317 exception applies if it's same office for the subsequent election. So 85306 applies in both instances. It's not just when they go to a different office, just to get the record clear on that issue. And I agree with her position on the authority of the commission to make these sort of decisions. I think these are the decisions for which the commission largely exists, is to fill in these gaps. This is the sort of situation where you had a ballot measure and you had everyone vote on it. And these are the sort of situations that people don't contemplate. And sure, we could go back to the legislature and ask them to, make a change. In the meantime, there's elections going on, and we're getting questions about these issues, and we have to answer those. And there has to be an answer that we give them one way or the other. So I think this is precisely what the good thing for the commission to do, to answer these questions, have a definitive answer from the commission, and if the legislature disagrees with the answer that the commission comes up with, obviously they can come back and change the law.
Noted, Mr. Bain. Go ahead, then we're going to go to...
Not to minimize the importance of elections, but we're referring to advice letters from 2006. So I think in terms of, I think it's important for us to get it right, as opposed to we have to adopt the regulation right away, so.
All right. Commissioner Wood?
Thank you, Mr. Bainbridge, for setting me straight. I appreciate that. It was like jumbled in my head last night when I was trying to read it, so I appreciate it. I wonder if the refund option would set a really weird set of adverse or like unintended consequences in motion, in which candidates who win outright in the primary would still have their name on in the general in order to avoid having to refund. But I mean, because they would be basically running unopposed, right? In the general. I mean, I don't know how it's all set up at the, in these systems that do this, but that would be kind of weird. And maybe it wouldn't happen. Maybe I'm just like tilting at windmills or whatever the perfect analogy is there. But it might be helpful to hear from county election officials as to whether they, think this is going to make their ballots longer and make their elections more of a pain in the general if this sort of thing happens. But maybe I'm way down the logistical rabbit trail here.
I can comment on that. I did talk to some of the local elections. I think it's not up to the candidate. So in that case, that it's because it's by local ordinance, they would just win outright at the primary. So it wouldn't be a discretionary matter on their part to sort of choose to participate in another election.
Cool, thank you.
So there wouldn't be that sort of workaround available.
I have a clarifying question, not a cause more work question. So let's say we went with the scenarios where they had to do attribution, option number 2. Is it contemplating that the attribution is for the general election and not the primary election? So they'd still have to run for a primary again and raise new funds for that, but the attribution is to a general election down the road. Say you're a supervisor, you raised money in both the primary and general, you won in the primary, we adopt option 2, and you have to do attribution. Do I open a committee for 4 years later and the attribution is to the general? So general to general, or is it within the candidate's discretion? I've tried to make sense on that one. Do you want me to clarify the question?
No, I think I understand what did we?
If the regulation, whatever we adopt, if we adopt number 2, I think we need to be clear on what they attribute to. And it's perhaps already in the attribution rules that we have, but given what we're trying to fix, we don't want to cause another problem.
Yeah,
I can tell you as I read it, and whether this is the intention or not may be a different thing, but as I read it, you're saying that it shall be, it can be transferred to a committee for a subsequent election to the same office and shall be attributed. It doesn't say it has to be for the general. It's just when you open up your
next
26 committee,
yes,
you have to attribute it. And so it goes against the contribution limits for those contributors. That's the point. It's not specific to versus general.
But don't we have a situation where, okay, does that mean that I get to go back to a donor and ask them to contribute to my primary because I attributed to the general down the road, or do I only get to ask them to contribute to the general?
So your
this is down the road.
Can the candidate choose to attribute to the general for the subsequent?
I just want to know what we're going to be telling people. We got to be pretty specific. If we're telling them you're going to attribute, and we allow primary and general maximum contributions, what are they attributing it to so they know what they can still raise and that people can still give? If we're not clear on that now, or if it's not already clear somewhere in the statute, I'm just going to offer that as something to make sure we're clear on if we adopt number 2 down the road. Option 2.
In my experience, it's attributed to the next primary election.
Okay. And I just don't know if that's clear already in the statute or if by practice or otherwise, but I put that out there so when this comes back, we're clear.
Yeah.
We don't create another issue. Thank you.
All right. I want to take a step back for a second, I think, and ask you this question. So based on your review of the various statutes at issue here, why did the legislature choose in this statute to require the return of general election funds for candidates that lose in the primary or withdraw from the general election? Do we have any understanding of what is the principle driving required refund in those circumstances?
I think it's based on the idea that they're no longer candidates for office, so the idea that the funds are held in trust for election to office, so that if they're no longer candidates, they would require them to return it.
Okay, so taking our novel fact pattern that we're trying to solve for here, when somebody wins outright in the primary, because I think, Commissioner Baker, you hit it right in the head when you said it's really a question of how do you treat them? Do you treat them as having withdrawn, or do you treat them as a victor who went all the way through the general? And so I think that's correct. That's the ultimate question for us. The principle animating the current rules, where you have to give the money back if you don't participate in the general, seems to be that if you're not actively in that election, then you're not in a position to use the money you raised, and therefore you should have to return it at that point.
I get it, but then there's the flip side, which is if you won and you have leftover funds, you are allowed to move it over instead of refund. Which is it more like is ultimately what we're going to have to get to.
Yeah, but here's and that's why I want to drill down on that, because I think I had the same initial reaction. And then I kept thinking about it. It's like, well, there is a distinction. Here's the distinction. You win in the general, you have probably spent a good chunk of that money. You've actually utilized that money and participated in that election. If you win outright in the primary, you never reach the general. So you would have a war chest built up for a general that you never had to touch because you never actually participated in that election, that you could just roll forward into your next election.
Maybe.
Or a primary.
Yeah. Maybe, but we also allow that, again, if a legislative candidate wins if somebody wins the general, it's just, I don't know that we'll solve it here, but yeah.
They've run in the general. They've had to campaign in the general. They've spent money in the general. They've done something with that fund.
Yeah.
Yeah, so if you're a candidate.
Seems like that's kind of one of the principles.
And that was something sorry if I'm jumping in.
No, I get it. But I can also see someone seeing it differently, which is I'm treating my primary like the general. I'm going to make sure that I win it as a general election. So we're kind of trying to get a little bit in the head of them a bit. It's just which one you see it as.
Well, I think that's right. And because I think if you're running in that type of an election, you do want to treat the primary like a general.
You want to be done.
But here's the thing, is you've maxed out primary election contributions for that purpose, right? So you may treat it like a general, but you're legally not even allowed to touch the money for the general, no matter how in your mind you're conceiving of that primary election.
Yeah.
We have two discrete contribution limits for two discrete elections. And it just seemed, I think that's like the underpinning of 85318's refund requirement, is you're not actually running an election, so you're not actually spending the money, so it wouldn't be right to allow you just to roll it forward.
Yeah, because in theory, there's no money left over because you never ran. It's just all kind of sitting there. So I think that's kind of the difference. I mean, it honestly, I think the point of these local ordinances is kind of to alleviate the burden of these candidates from, okay, now you have to, you won the primary, you was essentially one office, but now we're going to put your name on the ballot again and make you sort of go through the motions, and they've decided that that's not worth doing. But then, in that sense, those funds aren't left over because they never have to spend anything.
Well, I commit to you and the public, I'm keeping my mind open with option 3. It may be that through this regulation comment process and thinking about the excellent points that you've raised and my colleagues have raised, I could get there. It's still the one, just going to say that. Thank you for the perspective.
All right. Any more commissioner commentary for Mr. Norton? I think, Mr. Norton, you've heard from us, we're very interested in any legislative history.
Yes.
Particularly, what is the purpose underlying this? I mean, we just talked about it as if we're right. I mean, maybe there's something in the record that tells us there was actually a different purpose animating these rules, and we really ought to know.
Yeah, and if there was if there is any legislative intent or commentary in testimony or otherwise on why they even came up with the carryover exception, why they came up with the attribution rules, it may be that there's none because they were focused on other things in Prop 34. But if that elucidates where we might be able to go here, and then having the statutory hook is going to be very important to hear about. Thank you.
Any public comment? Oh, sorry. Sorry, Commissioner Wood.
Sorry, just the thing Chair Maddox said just then was pretty persuasive to me, that they're not actually having to campaign in the general, so they would kind of, you didn't say it in these words, but like unfairly have a ton of, money, like a bigger war chest that they could pass forward. So I would actually also be interested in knowing what the history of a few of these kind of the bigger cities maybe that do this, you can win outright in the primary system. I kind of want to know what they're thinking in making that rule, because if it's about going through the motions and reducing the burden on the election administrators, that's one thing. But if they're talking about money and donor money and campaign expenditures and things like that, that would be really interesting to me too. I know that we don't regulate based on that really, but I still think it might help shed some light on this decision that they've made to let people win outright in the primary with a majority.
Yeah, I think that's a good point. Commissioner Wilson.
Kind of an excellent point by Commissioner Wood, and as a follow-up to that, it's my understanding, Mr. Norton, that the state superintendent is the one exception at the state level where you can, you have a similar situation which you have throughout local government.
Yes.
So I think it'd be also, makes sense to look at the superintendent of public instruction and see what the trends are there as well.
Any other commissioner feedback before we open up for public comment? All right, public comment on item 9, pre-notice discussion of our regulations regarding refunding contributions. Do we have any public comment? Hearing and seeing none. Thank you, Mr. Norton. Great job. That was a lot of dense material, and I thought you did a great job walking us through it.
Thank you.
So we look forward to seeing you in Fresno in
Yes.
October.
So can I just, sounds like we're bringing back all three options with some additional research, whatever we can find on the areas you mentioned, and we can have the discussion again and have the options available for each. Is that?
Yes.
Okay.
Thank you.
All right, thank you. Guys want to take a 5-minute break before we launch into our presentations? All right, 5-minute comfort break, and we'll reconvene. We'll just reconvene at 11:50.
No.
All right, let's go ahead and reconvene here. We are on item 10. This is a presentation on our FPPC email advice function, and with us is Assistant Chief Counsel Suki Brar. Good afternoon.
Good afternoon, Chair and Commissioners. Today I'm going to give a presentation on our email advice processes. Is the presentation visible? Okay. Today I'm going to cover, first of all, I'm going to give an overview of our email advice processes. And then I'm going to go over ensuring how we ensure accurate and consistent advice, and then finally our email advice audit program. So I'm going to begin with our email advice team. We have an excellent team that works on getting all of our amazing advice out there. We have the Assistant Chief Counsel, which is myself. We have 9 staff attorneys that work on email advice. We have a staff services manager that is not an attorney that manages directly 3 political reform consultants that answer email advice, and also a staff service analyst. On this slide, this is going over the nuts and bolts of how we process email advice. And so we have an email advice box, advice@fppc.ca.gov, where anyone from the public who has duties or obligations under the Act can email in questions that they have about how to comply with the Act. That email box is monitored by a political reform consultant of the week and an attorney of the day each business day. Political reform consultants handle routine questions related to Statement of Economic Interests, Form 700, gifts, lobbying, and campaign. Attorneys handle conflict of interest questions, advice letter requests, and questions that involve legal research or analysis in all areas covered by the Act. And questions that cannot be sourced from existing materials or are complex are elevated for manager review, and a manager will go and do another review to make sure we can't source them from somewhere. And then conservative advice is given via email, or it's elevated to an advice letter or an opinion, or even to a regulation project for the commission to consider. And so this slide goes over the volume of email that we receive each year, just to give you an idea of how many we handle. We have 2021 and 2022 advice numbers here. 2021, we have about 7,105. That is in a non-election year, so that's why you see a discrepancy between 2021 and 2022 and the numbers there. We tend to get far more emails in an election year than we do in a non-election year. And as you can see on the slide, we handle over 80% of those within 24 hours. That is always our goal. Sometimes they take a little bit longer depending on how many are coming in and the complexity of the question. And for those that are handled that take longer than 24 hours, we handle a majority of those within 48 hours even. So we aren't taking very long to answer these, so I'm pretty proud of our staff for that. And so next, I want to talk a little bit about how we ensure accuracy and consistency between all of our staff giving this advice on email. And first of all, it starts with training of staff. Our political reform consultants, when they come on, they receive training on how to use our various educational materials, including our manuals, fact sheets, the website materials, advice letters, etc. Attorneys also receive that training. And political reform consultants are advised to only respond to email requests on their own where they can actually source the answer from those materials. Anything more complicated that requires a legal analysis is flagged for an attorney. And then we also give monthly email advice updates to staff just as reminders of what's coming in so that they can refer to those and be aware and make sure that we have consistent advice going out. We also do weekly updates on recent advice letters that go out to staff. This is because sometimes, though they are available online and on databases such as Lexis and Westlaw, they don't always appear there right away. So we send them out to staff so staff is aware of them quickly in case questions come in that are related to those. We also have saved materials with common questions and answers and how to word them that staff can refer to. And we have past advice saved by topic for easy reference that staff can look at. So they can look at our educational materials, but then they can also look in a subject matter folder to see if we've advised them exactly how to word a response. And then finally, we have monthly staff meetings to provide any additional updates that may not have already been covered in other areas. And so now I want to talk a little bit about our email advice process, audit process. About a year ago, we began conducting a formal weekly audit of the email advice that goes out. And how we conduct that is myself and the staff services manager, we select 50 emails a week, we switch off weeks, for a random audit. And if corrections are needed, well, we audit them actually we look at them for accuracy, we read the question that came in and the response that went out, and we look at them to see if there's anything else that could have been done differently or if there was an error. And then we record that and use that for staff training purposes later, and also, if needed, follow up to the requester if there was an error. And we do that very quickly. The audits are done every week, and so it's usually only a matter of a day or two, sometimes a little bit longer depending on if it came in on a Friday and we're looking at it the week after on a Monday or Tuesday, where we follow up if there was any issues. And so on the next slide, I have our audit stats for the past year for the audits we've conducted and what we found, and it's separated out by quarter on the left column, and then on the right at the top, you see the different areas where we look for things in the emails that we're reading and things that we've identified. And so the first column is if the political reform consultant or attorney working on the question maybe misunderstood the question or only answered part of the question. And we have the numbers there. You can see they're very small in comparison to the number of emails that we've audited. And in that column, I want to say that the few that there are there, even for those, often correct themselves, because when the requester gets the response, they notice that's not actually what I asked, and they'll write back already. That's most of the time. And so then they're able to get what they needed because of that. And if not, we follow up, and if that didn't happen. In the second column, that is the column where the answer that was given was correct, but as managers, we felt that additional information could have been helpful to that person. So they may have gotten an answer to the specific question they asked, but there might be other information related to that that they might face. And if it was clear that they may not know that, then maybe we wanted to add that. So we'll train staff to do that next time. And then if needed, if we think it's necessary, to follow up with that requester also and give them additional information. And then the very last, the second to last column is where we found incorrect response given. And as you can see, that's also very small. And in the past quarter, it was down to 0 after this. I think the audit has been helpful in helping staff be more careful as well. And so we hope to see that number stay very low going forward. And again, with those, we follow up very quickly and correct with an apology and give the correct response if we happen to find that. But again, it's also a very, very small percentage. Okay, and then finally, sorry.
Can I ask you a question? So for the incorrect response given, I mean, which is less than 1/3% of the overall. So you guys are doing great, like 99.999% of the time you're getting it right. My question is, when you do identify an incorrect response, what's the interaction like with the requester then? Because it sounds like you can identify that within a couple days. What happens next?
So what happens next is we talk with the staff member who handled that question. We let them know that we found an error, and they follow up in the same email chain with that requester with an apology and with the correct information.
Right. If it probably rarely happens, but in a case where a question came in, let's say on an SEI, it was right before the filing deadline, they got an incorrect answer from us, filed in reliance, and had to amend. I mean, do you share that information with enforcement so they know, hey, this person filed something and had to amend, but it was our fault? Like, how do we ensure they're not going to be subject to some kind of enforcement action later on?
I think if that were to happen, I think, and I've seen this in the past, is that person, when they get that notice from enforcement, they will say, hey, I sought advice, and they will pull up that email. And in those cases, I don't see that enforcement would prosecute them if they relied on advice that we gave them. I can't speak for enforcement, but that's what I think that they would do.
Yeah, okay. I just wanted to, I mean, it's an incredibly small percentage of time, the universe that we're even talking about, but I just wanted to make sure I understood what the reaction would be.
Yeah.
All right. Sorry, those are the only questions I had.
Okay. Okay, and then this slide is just looking forward. We're always looking at ways to improve our advice processes, and we are currently exploring options to more efficiently receive and sort our advice requests across all formats. We give advice via advice letter, phone, and email. So we're thinking about including an online submission form or using a database and/or a chat application. Also, we're exploring technological options for further interconnecting all of the types of advice we give, centralizing email and telephone and our formal advice processes. And finally, we're exploring technological options to more effectively track and record our advice requests across all formats.
Yeah, go for it.
Yes, thank you for the presentation, very, very informative. Just from a technical standpoint, if someone's listening to today's hearing, and I'm sure there are thousands doing so, what would be the process for submitting an email advice request? And when that request is submitted, is the requester's name confidential just within the FPPC? I mean, what's the actual process?
So the process works very much like all of our email accounts we have at home. They email in, it comes from their email, the email advice@fppc.ca.gov from their personal email account or their work one. And it comes in just like any other email. It has their name on it and their email. That's how it shows up in Outlook here.
Right, but can someone make an anonymous email advice request, or they have to identify, my name is, John Smith?
I wouldn't say they necessarily have to identify, but they have to give us enough facts so that we can actually give them helpful advice. So it's possible they could have an email address where it's not easy to identify them, but they can only ask about their own obligations under the Act. They can't ask for third-party advice, so they have to make it clear that it's happening to them.
Okay, that's a good clarification.
Yeah.
Thank you.
Mhm.
Thank you. Great numbers. So, well done and just how, it's a human endeavor. So there's bound to be error, especially with such a trove of advice letters and legal opinions going back many decades. So I just want to echo the chair's observation that these are some very small numbers where there's either a need for correction, amplification, or whatever. So my first question goes to the slide where you're identifying volume and the response time, which is 24 hours. And I think we've noticed this in the legal division's reports to us and updates from time to time. And I think that is really great numbers. I'd like to understand what response means within 24 hours. Does that mean the advice, excuse me, the advice, except in the few that go beyond 24 hours or even beyond, the advice been given? Or that there's been an acknowledgement or telling them, hey, we need to bump this up to a formal advice, but it's not quite closed yet. Do these numbers reflect what I would consider, closure?
Yes, they reflect that the response was given and closure.
Yeah, the substance. Okay, great. Well, I think that is really good to see. The other question I had goes to your last slide where you're talking about looking forward and how to improve. Do you have some thoughts on the timeline by which you're hoping to tackle some of those issues? And what would be helpful to have, either from the commissioners or the commission in general, either budgetarily or soft-wise? What's your timeline and what would be helpful to have?
I'll take that one. We've had some meetings with our IT department to find out what is possible from a technological standpoint. We'd like to get some sort of system in place that sort of centralizes all of this. So at this point, we're working with them. They have many other projects. So it's kind of working with them to figure out what are the options are, and then we'll go forward with choosing. So I'm giving you a vague answer, but it's in the process, and it's what could we use? You could probably ask Jesse that, and he'd probably say more staff and more money. But to the extent they have capacity to work with us on this, that's where we are in the process.
Okay. Yeah, that would be, if that does come forward, if there's a commission level thing that we can do to be supporting. If it doesn't sound like there's guidelines or guidance anyone seeking from the commission about how to prioritize, and I don't think that would be appropriate for us because you're already on it. But I would be curious along the way if there's something at our level we can do to be helping, I'd be eager to do it. And my final one has to go with, you mentioned phone advice. My understanding from earlier presentations in the last year or in response to questions is that the phone line is not tracked as much in terms of Catherine Baker called to get advice on how to comply. And are there any tracking measures that you have here or things that you're practicing with respect to email that you think is appropriate to carry over to the phone line and make that more efficient, whether for tracking if someone's asked for advice or just in general processing them?
I think you've hit on an important point and why we try to favor email advice over phone advice, in that there is a record. We can look back and see what advice we've given. The person who receives the advice has a written statement of what the advice was. They can go back and look at it too. So our overall goal is to push more of the advice function into more of a written email format. It's still responsive, as you can see. I think people like the phone because they can get an answer right away. The email's not quite right away, but it's pretty quick. So because of that issue, we can't record people's conversations, without jumping through a bunch of hoops. And there really isn't a phone system that would work. So instead of trying to upgrade the phone system, we're trying to move towards a more interactive digital system that kind of covers phones and emails in one.
And, email does lend itself more to a record where it's clear. You don't have to create a document to keep tracking. And I don't want to take us off the freeway too much, but since it is relevant, if someone sought the advice of the FPPC, it's one of the factors that we use. I don't know if we've ever looked at keeping a log of, again, Catherine Baker called on this date and sought advice. Or if somebody would always have the ability to come and say, hey, I did call on this date and you told me to do exactly what I did, and we'd have no way to prove that. You haven't raised that as an issue, so I don't know that resources are required to do that, but I keep that in mind because we do still offer the phone as a option, and it is a factor in stipulations.
Commissioner Wilson?
Kind of as a follow-up to Commissioner Baker, it's my understanding that on the FPPC's website, there's a search function for advice letters going back to the mid-'70s. So could you kind of expand on how that works? And that, I'm assuming, is tied into the email advice process.
So the database on the website is it doesn't include our email advice. It includes advice letters and opinions.
Just
Yeah.
advice letters?
Mhm.
Okay.
And opinions, yeah.
Yeah, you might want to clarify that because if you go on the website and you put in
Okay.
advice, then you get, that link. So I
Okay.
think it's important for, the public to be able to distinguish advice letters, email advice, even though, I think you've clearly outlined that distinction.
Sure, we will do that. Thank you.
Commissioner Wood? Yeah, I think you're muted, Commissioner Wood. We can't hear you. We still cannot hear you, Commissioner Wood. All right. You can hear us though, right, Commissioner Wood? Okay.
Yeah, I can hear you fine.
There you
can't
are.
hear
You're
me.
back.
Oh, really? Okay.
Yep. Good job, man.
My headphones sometimes get a little bit greedy. Sorry about that. I was saying thank you for the presentation. I also think a call log would be pretty helpful if we could manage it. Because I know, I hate doing back and forth email stuff. I would much rather be on the phone. And so there's always going to be people like that. And I think we'll always have a phone number posted where people can call, even if it's a few hours a day, a few days a week, or whatever it is that we're doing right now. So I just want to second what Commissioner Baker said about the log. But what I really wanted to say is I love that you're doing these audits on the emails. I think it's so responsible as public servants to do this kind of thing, and I'm amazed by the accuracy rate. So I just wanted to pat you on the back for that because I'm very, very, very impressed with that.
Thank you. Thank you very much.
So I had one other question for you, and that is, the audits are fantastic. I'm glad we're doing that, and you deserve a lot of credit for that. What about surveys to the requesters? Like, have we thought about asking for just feedback from the regulated community and people that are making use of our email advice function? Hey, are there things that you're experiencing on your end that we could do to maybe improve what we're doing? Because I think in frankly, part of the reason I even thought about that, and it sounds like we're already doing it, is when you're reviewing, auditing these records, you're going beyond, did you answer the question? And you're looking at, hey, proactively, we could have given information on this, this, and this based on what they gave us. I think that's great, and it just makes me wonder if there are other things that we might be able to be doing more for requesters. But I think maybe doing a survey and getting feedback might be one way of figuring that out.
Sure, yeah, we haven't done a survey. We do get feedback from our email requesters, often thanking us for the help, and that's pretty much the extent of what we've done in terms of getting feedback, but we haven't done a survey yet, so that, yeah, I like that idea.
All right. And then second question for you. So you're gathering all these different advice requests, we're cataloging them because they're being done by email, et cetera. When you, to the extent that your staff develops, identifies a trend of particular areas that we're getting a lot of questions about, how, if at all, do you liaise with other units in our agency? Like I'm thinking particularly outreach and education on how we push out trainings based on the feedback we're getting on what the most common questions are.
Yeah, so we definitely take our most common questions, and a lot of them are already in our educational materials and in our trainings. A lot of what we get asked, a majority of what we get asked is already included somewhere in our educational materials or our training, and maybe the person asking doesn't know how to look for that or where to find it, or maybe just wants to be able to email and not have to go look for it. But for things that aren't already clear in our educational materials, I keep track of those things and I email them to our education unit for inclusion in our educational materials. And so you'll see, in the manuals that are on the agenda, you'll see some of that in there. So that we definitely keep track of them and we forward them to education to put into fact sheets, manuals, and form instructions.
All right. Well, that's good to hear. I think that's great data sharing among your colleagues, just to kind of get the word out in common areas of concern. So that's all I had. Great job. I think you guys did great. Commissioner Baker.
Likewise, it's not surprising, but also very reassuring to see such great numbers and the ethic to it. Just in follow-up to the chair's point about a survey, I suppose it could be like a one-time survey instead of something. There's options on the spectrum. One of those annoying emails we get after we go do something. You get an email that says, hey, can you tell us how we did it? Sometimes they even call you. It's usually when you get your car fixed. I'm not sure. That's one end of the spectrum, and they might be ignored, and who knows how many people to something's automatic in the signature line, which is in response to this. If you have any feedback, we welcome knowing that. Please provide that. We'll use it in the future, and everything in between. So I throw those ideas out. I'm sure you'll come up with other good ones too. Thank you.
Thank you.
Any additional questions for Ms. Barr? Hearing and seeing none. Do we have any public comment? We are on item 10. This is a presentation on the FPPC's email advice functions. Hearing and seeing none. Thank you, Ms. Barr. Great job. Keep it up, and we'll see you soon.
Thank you.
All right, moving right along. We're at item 11. This is our 2023-24 budget presentation. Well, welcome to the table our Chief of Administration and Technology, Ms. Hahn. Good afternoon.
Good afternoon, Chair and Commissioner. I'm here to present the Budget Act of fiscal year 2023 to 2024. I would just like to provide an update to you all that based on Commission direction, staff submitted 7 BCP resulted from passage of legislation and additional staff resources. FPPC have been allocated 15 new positions, which increases our 23-24 overall budget by $2.2 million. I'm here to answer any question you might have.
Can you give us just a brief sense of where we're at? I mean, it's great that we're getting additional staff resources, particularly for enforcement. I think 7 of those are enforcement positions. So can you give us a sense of where we're at timeline-wise and filling those new positions?
So the budget allocated to us on July 1st of 2023, as of today, we are 75% either advertised or hire of those 15 positions that we were allocated already.
Okay. All right. Well, that's good news. All right. I don't have any other questions. Commissioner questions? No? Commissioner Wood, anything? All right. Any public comment on item 11? It's our 2023-24 budget report. All right. That was easy. Thank you, Ms. Hahn. right, moving right along, move to item 12. It's our audit division update. And with that is Chief of Audits and Assistant, Ms. Shaw. Good afternoon, Ms. Shaw.
Good afternoon, Chair and Commissioners. Just give me a sec to set up. All right, good afternoon. My name is Shraddha Shah. I am the Chief of Audits and Assistance at the FPPC. As requested by the Commission earlier last year, I'm happy to present today's update from our division. I'll cover a few key topics, including audit requirements, an overview of our audit process and timeline, fiscal year 2022-23 updates, and some common audit findings. To start off with, I would like to speak about the importance of our audits and the purpose behind it. Our audits are performed to determine the auditor's level of compliance with the Political Reform Act's record-keeping and disclosure provisions. The Political Reform Audit Program acts as a fraud deterrence tool that minimizes the risk of non-compliance with the PRA in California. Our audits educate auditors on the importance of proper record-keeping and campaign statements and reports. In addition, our audits serve as a tool for continuous improvement. Through our audits, we as a division can recommend updates and amendments to our campaign regulations and guidelines. Through these activities, we support the agency's mission to ensure that public officials act in a fair and unbiased manner in the governmental decision-making process to promote transparency in government and to foster public trust in the political system. Moving along, I will speak about the audit authority that is provided to the FPPC and the FTB. Audit authority is provided to the FPPC and FTB per sections 90,001 through 90,008 of the Political Reform Act. Per the Act, some mandatory audits are performed by the division. The FPPC performs audits of statewide candidates, candidates for Board of Equalization and their control committees, CalPERS candidates, as indicated in blue fonts on this slide. The Franchise Tax Board performs the rest of these audits. These audits are either selected because the entity meets a mandatory threshold or because they have been randomly drawn in one of our public drawings. We select 25% of lobbying firms and lobbyist employers. Statewide Supreme Court, Court of Appeal, and Board of Equalization candidates are selected if they have $25,000 in contributions or $25,000 in expenditures, whether by the candidate or by their control committee. If they have less than $25,000 in contributions or expenditures, they're subject to an audit on a random basis, and they're drawn through our random draws, and we select 10% of these candidates. For legislature or superior court candidates in a direct primary or general election, we select, if they have had $15,000 or more in contributions or expenditures, they are selected for an audit. If they have less, we randomly select them from during our public draws. We select 25% of Senate districts, 25% of Assembly districts, and contested judicial offices. General purpose committees that have raised or spent more than $10,000, and those that have not been audited or have not been determined to be in compliance in a previous audit are subject to an audit again. Of the previously audited committees that were found to be in compliance with the Act, 25% are randomly selected. For local jurisdictions, a group of 20 local jurisdictions, including 8 counties, 8 cities, 2 school districts, 2 special districts, are selected through random draws. And for CalPERS Board of Administration candidates, they are subject to an audit if they have received contributions aggregating $5,000 or more for an election. Our draws are public, and they can be attended by interested parties, either in person or virtually now. We announce the dates, times, and location of the draws on our website. These draws are generally held in our hearing room, and the next public draw will be held on August 23rd at 10 a.m. here in this room. And moving along, continuing with our audit authority, We also have the authority to perform some discretionary audits. Section 90,003 of the Act allows FPPC and FTB to conduct audits at our discretion. The Act states that the FPPC and the FTB may conduct investigations and perform audits with respect to any statements or reports required by Chapter 4 or Chapter 6 of Section 90,003. And in addition to these, we also have the provision to do contractual audits. Per Section 83,123.5 and 83,123.6, the agency can perform contractual audits. Over the last few years, we have entered into various contractual audits with other agencies. These have included the City of Sacramento, the City of San Bernardino, and the County of San Bernardino.
Chief Shaw, I wonder, can you give us some examples of circumstances in which you would exercise your discretionary audit authority?
These can come either from a referral case, if somebody has referred or if somebody has made a public complaints, or we also monitor the news or the social media. So if we know of something going on, we can conduct these audits based on our discretionary provisions.
I'm mindful of the conversation we had recently about candidates who withdraw, what they do with funds. But if a candidate opened a committee and I don't know if they withdrew, but they closed the committee and disposed of the funds, could they still be randomly audited down the road if they're pulled in the draw? So I'm thinking of someone, okay, yeah, good to know. Just because you closed your committee and dispersed your funds, an audit can come in future years. If your spot is drawn, you could be drawn. Okay, good to know. Want to make sure we capture those folks too.
In this slide, I will outline our typical audit process. Once the selections are made, our audit supervisor proceeds to assign cases or audits to our respective auditors. The first step during the audit process is the initial contact letter. This letter informs the auditee about the audit. It includes a list of requested records and an audit questionnaire. We ask our audit contacts to complete this questionnaire, which provides comprehensive details to the auditor. It covers aspects such as the treasurer's identity, committee record keeping, preparation of campaign statements and reports, bank statements, bank accounts, contributions and expenditures, etc. The auditor makes the appointment call where the initial discussions regarding the records are made and discussions about what records will be requested during the audit. All candidates and committees are required to keep detailed accounts, records, bills, and receipts as necessary to prepare their campaign statements and reports. These records will be requested and need to be produced in response to a notice that the FPPC or the FTB is conducting an audit of the campaign. Regulation 18,401 details the record-keeping requirements for most of our campaigns. The second step in the audit process is the fieldwork. Once the auditor receives all of the documents they have requested, they proceed with the fieldwork phase. Fieldwork is now conducted remotely since the COVID-19 pandemic because we have been able to receive electronic documents. This has allowed us to conduct our audits remotely, so most of our audits, I would say 99% of them, are now conducted remotely. The auditor will review the bank statements, complete the bank reconciliations, contributions and expenditures are traced from supporting documentation to the information reported, and they will review the campaign filings and verify timeliness, accuracy, and completeness of the documents. Throughout the fieldwork phase, we collaborate very closely with our auditees. Going on, the next step would be during the fieldwork phase, if any discrepancies are noted, they will be researched. The auditor will reach out to the audit contact. This can be the candidate or the professional treasurer or whoever has been assigned as the audit contact. And we reach out to them, we discuss any discrepancies that we have noted and figure out, why something doesn't tie to the records they have provided, or usually we are able to resolve because there wasn't a document provided or they missed a receipt or something. So once all discrepancies are researched and discussed with the auditee, the auditor will complete the audit work papers and reconciliations and conclude the field work. Following this, a post-audit conference is held with the audit contact or the professional treasurer as applicable. If any of the noted discrepancies end up being a material finding, we gather explanations from these individuals, and these explanations are then incorporated in our report. Next, the auditor prepares the audit report, the audit work papers, corresponding letters, and the summary of findings. The audit report summarizes the filer's conformity with the disclosure and record-keeping requirements of the Act and any findings due to nonconformity with the Act. Moving on, they will submit the audit into review. The complete audit file, which includes a report supporting schedules, evidence for identified findings, and any other schedules are submitted into quality review. Following the generally accepted accounting standards, all reviewers are involved in the review are independent of the audit, which means they have not worked on any part of the audit. We now have a new audit process in place where we have our 2 senior auditors trained with first-level reviews as well. This has helped eliminate bottlenecks in our review process that had existed before. In the past, only the supervising management auditor was responsible for performing all reviews, but now with the 2 other auditors performing first-level reviews, the supervising management auditor is able to focus on other tasks in the division. For complex or any large audits, the 2 senior auditors have been properly trained and they are now performing the first-level reviews. Once any adjustments are made based on the reviews, the work papers are updated and then the audit is then handed over to me for final review and approval. And after my review, I sign off on the corresponding letters, and the report is sent out. Once the reviews are finished and any final adjustments we make, the reports are sent out over to the candidate, the treasurer, professional rep, secretary of state, and as applicable, we also send it out to the attorney general and the district attorney's office. Additionally, all reports are sent over to the enforcement division for their assessment. Once we have sent out these reports, we consider the audit process closed on our side, on the audit side.
Just a
Yes.
couple questions. One, kind of taking a step back, your audit division, all the steps that you've referred to here, you're an independent division within our agency, and so
Yes.
you are walled off from enforcement.
Yes, I will
Probably important to
touch on
mention
that in one of the slides coming up.
All right, cool. And then the second question for you is with respect to field work being all remote, does that mean that auditees, the people who have to turn over their records, are they required to scan all of their records now and transmit them to us, or is that just an option for them? How does that work?
They are not required. It is an option, but since the pandemic, most of our auditees are working remotely and they prefer sending us electronic documents. We've still had some that send in paper copies, but that hasn't created any backlog or any roadblocks in our process because we are still able to do the audits from here, from remotely or in the office rather than sitting in their offices.
Okay.
So no, to answer your question, no, it is not, it is an option. They can do that. They're not required to send us electronic documents.
Okay, cool. I just wanted to clarify that. Thank you. Yeah, Commissioner Wilson.
I don't want to drag this out, but just kind of a technical question, follow to Chair Maddich. Let's say that there's a situation where you've requested certain information, certain records, and it's not available. I mean, then what happens in that situation? I mean, are there any potential penalties or?
Yes, I do have that as well.
I'll
in
wait
one
till
of
you
the
get to that.
future
Okay,
slides.
all right.
Any other questions before I move on? Okay. So here I will talk about our typical audit timeline. On an average, our audits take about 60 to 200 hours to complete. What that means is a smaller audit where the candidate's financial activity falls below the 25,000 threshold maybe and involves only a few contributions or expenditures, that audit would be around the 60-hour mark. We still have to prepare the bank reconciliations, trace the contributions and expenditures, prepare all of our supporting schedules, just like any other audit. It's just that due to the fewer transactions, the analysis part takes less time as compared to an audit where their candidate's financial activity involves numerous contributions, expenditures, loans, or other complex transactions. These audits usually require more in-depth analysis and are closer to the 200 hours to complete. We usually assign these complex audits to our senior auditors just because they have more experience in these areas and they're able to more efficiently handle these complex matters. Our audits generally cover campaign statements and reports filed during the previous years. This may include this may be the last 4 years for candidate control committees or committees primarily supporting or opposing a candidate. And on the flip side, for maybe lobbying firms or lobbyist employers or general purpose committees, this may cover the last 2 years. We begin our audits after the last filing date of the preceding election. So we never audit a candidate if an election is open. We always wait until everything is closed and then we start the audits. FPPC follows audit standards derived from the FPPC regulations, California state standards and policies, and the generally accepted auditing standards of the American Institute of Certified Public Accountants in each of our audits.
Just a quick question. So you mentioned in the previous point that you don't audit someone while the election is pending. You wait till it's closed.
Yes.
Just to distinguish, somebody could be running for reelection, so they've had to open a new committee, but you're just referring to the committee that you're auditing, or the,
Yes.
the cycle that you're auditing?
Yes.
Got it. Thank you.
Hi, Galena West. I just wanted to add that that doesn't apply to discretionary audits, which also can happen during an election cycle if something has been flagged as an immediate need.
That is true. So now I would like to touch upon our updates from the last fiscal year. And to the point that the chair had made just a few slides back, we are a standalone division now. We, as of December 2021, we are an independent division of the commission. We used to be part of the enforcement division. However, we are now independent and we report directly to the executive director. We do have an ethical wall between us and our enforcement division where we stay independent of their cases and they stay independent of our audits. So we do not share files or we do not have access to each other's workload. If we do need to consult with them, we do it on a formal basis. We have a formal process where we have contacts and we go through the chain of command for those requests. Over the last years, we have made other changes to our process. These include updating the audit manual to reflect organization, process, and regulation changes. The manual is used mainly by our auditors as a guide during their audits and for new auditor training. Our work papers were updated and streamlined over the last year where applicable, and any older versions were deleted. We ensured that all our auditors now use the new updated versions of the work papers and include, our work papers now include automation and formulas, and that only one version of a work paper exists. This advancement has enhanced our audit efficiency and effectiveness while diminishing human errors linked with data entry and manual calculations. And as mentioned earlier, we have now introduced our new audit review process that involves our two senior auditors. And although our complex audits now undergo 3 levels of reviews instead of the previous 2, this new approach has actually accelerated the process. And furthermore, this modification has enhanced the quality control of our audits by adding additional layer of review. In addition, like I said before, our supervising management auditor can now focus on other tasks rather than being bottlenecked into audit reviews. We have also increased focus on auditor training over the last year. Our auditors took additional classes through the Cal HR program, and they also took some additional classes through other vendors which provided audit-specific training as well as training such as Advanced Excel, which is very essential to their jobs. These auditors, we want our auditors to stay abreast of all regulation changes, process updates, and to keep up with any technological changes. In addition, all new auditors hired now, they receive one-on-one trainings from our supervising management auditor as well as our senior auditors. And for their, at least for their first 2 audits, we make sure that the newer auditors now shadow another auditor rather than working on an audit independently, so that they are able to learn the process, learn the regulations and everything before we can independently have them work on audits. Yes?
Thank you. Going to that first bullet point about, standalone independent division, I think perhaps a few moments ago in response to the chair's question on what's an example of, self-initiated audits, I thought you had mentioned that social media or maybe media coverage, and if there's a complaint that was filed, which is in the enforcement side, can you clarify then if there's a wall between enforcement and audit, but perhaps you might self-initiate after a complaint is filed, how those jive together?
If a complaint is filed with enforcement, we wouldn't have visibility to the complaint unless we have been formally told by enforcement that, there is such and such complaint, we would like you to initiate an audit or something like that.
And there's a formal communication
Yes,
happening?
there is a formal communication.
Just wanted to get that out there. Thank you.
And then continuing with our updates from last year, the audit division consisted of 7 staff members during the last fiscal year. We had 1 auditor retire effective June 30th, 2023, and we have hired another associate management auditor to fill that vacancy. She started yesterday. In addition, AB 794 passed last year, which gave us 1 more position, and we have hired a staff services management auditor as a result. SB 794 allows a committee to knowingly accept contributions up to twice the limit, so long as they return the excess within a specified period and do not use the contribution prior to returning it. This bill increased the complexity of tracing money, which is why our workload has increased, and we were granted that additional position because of that. Over the last year, we have adopted 17 audit reports, and I will touch on this in the following slide as well. In addition to our audits, auditors assist the enforcement division with investigations. We prepare for and work on random draws and other special projects as needed. And as for the investigations, I do want to mention that we do stay independent of the investigations unless an auditor assistance is requested. And that is the only time an auditor will be working on assisting the division. However, if there is an investigation going on a case, and if that same candidate has an audit, the auditor stays independent of the audit and the investigation. They do not work on both at the same time. As I mentioned earlier, we adopted 17 reports over the last year as compared to 13 in the previous year. These included CalPERS audits, County of San Bernardino audits from 2 different elections, statewide candidates, and lobbying firms and lobbyist employers. We currently have 33 audits in process. This data is true as of August 2nd, when I prepared this report. The 33 audits in process are in various stages, which include planning, fieldwork, and quality review. Typically, audits remain active for around 1.5 to 2 years as we gather information, reconcile data, and perform analysis. It is also worth mentioning that at any given time, an auditor may be handling 3 to 5 audits at various stages. They could be planning for one and setting up their audit work papers and then the audit file, while requesting documents for another one and working on a bank reconciliation. And on top of that, they could be finalizing a 3rd audit and have maybe 1 or 2 in review. I also want to, it's also important to note that we had some drawbacks in our processes over the last years. Not all auditors perform at the same level. Some of our auditors are more experienced and hence they are more efficient in completing their tasks as compared to our newer ones. But in addition to that, we also had a personnel issue during the last few years, which affected efficiency of our audit process. As a result of this personnel issue, some audits had to be reassigned to auditors and had to be redone. This created a disruption in our workflow as auditors. It did create a disruption in our workflow as the auditors had to temporarily shift their focus from handling their own audits to handling these reassigned audits. But the good news is that we have resolved our personnel issue, And this resolution is expected to contribute to a smoother workflow and improve efficiency going forward. We are looking forward to the next year with more optimism as we have all of our new auditors fully trained and updated work papers implemented. This makes us hopeful that our workload will go more smoothly without any more problems. Yes.
Commissioner Wilson?
I appreciate your detailed outline of the process, Chief Shaw. Just a kind of quick question. What is the scope of confidentiality with regard to the final audits? Is it strictly confidential? Is it accessible to, like, for example, the executive director? On the other side, the public, the media? What's the scope?
Our audit reports are public documents. So anybody who is interested in the audit document, the audit report or the details of the audit, they can request the documents and we can send it over to them. The executive director also can request anytime. However, when we have our audits in process, those are confidential, but once everything has been finalized and the audit report has been reviewed and it has been published, it is a public document.
Okay, thank you.
Go ahead and continue.
In a slide, I would like to touch on some of our common audit findings. Some of the findings noted in our audits, or more commonly noted findings, are failure to file FPPC campaign statements and reports, including failure to file on a timely basis. Another one is a failure to timely disclose the required information related to accrued expenses and sub-vendor information. And the third most common finding that we run into is a failure to maintain source documents for contributions, loan, and expenditures. Other findings we have noted are incorrectly disclosing or not disclosing all required information, failure to report non-monetary contributions accurately. What happens more often is that we don't receive all of the records we have asked for, rather than not getting anything at all. So if we have requested 10 items, maybe we'll get 7. But we haven't run into an issue where no records have been maintained. The records have been maintained, it's just that we generally, the finding that we have noted is, or the issues that we run into is, we'll request 10, we receive 7. This requires a lot of back and forth between the auditor and the audit contact, which it leads to delays in our audit completion. That is why some of our audits stay open longer, because we haven't received anything that we have requested. And in worst case scenarios, these can lead to subpoenas. And again, these are time consuming. And to answer your earlier question, we do issue subpoenas for documents that we haven't received on time. We do follow up multiple times. And if we still haven't received anything, we turn to subpoenas at that point.
Okay. You guys could follow up on that. A
Yes.
couple of meetings ago, we had a discussion about the process for voluntary compliance versus issuing subpoena in the enforcement context. Now it makes me wonder, for audits, you're seeking voluntary production of documents initially. On the enforcement side, I think we do that, we wait 21 days, and then if they don't, you're free to issue a subpoena, or they're free to issue a subpoena. Do you have a similar process?
We do. We
audits?
follow the same guidelines as enforcement.
Okay, so the delay shouldn't be longer than 21 days before you're issuing a subpoena if you're having problems, right?
Yes, except for, we recently had a situation where we were trying to issue a subpoena, but we were not able to get a hold of the individual that we were supposed to serve. It took about 2 months to finally get a hold of the person.
All right.
So things like that definitely do delay our audits.
How often is that kind of extraordinary effort required to obtain a document?
It's not very common. I would say, this is the first one I have seen that took so long since I have been here, and I've been here since December of 21. So this is the only one I have seen so far, which took so long to get a hold of the person that we were trying to serve. Usually they're much quicker. We haven't issued a lot of subpoenas over the last year, but the ones that we did issue, it hasn't taken too long.
Okay, all right, I appreciate that.
On the back and forth that can happen, that's, as we've learned from our enforcement team, sometimes they can't control how recalcitrant or intransigent, pick your word, delaying the other side is in responding. What measures do you have in place? Do you say, can you get this to us in 30 days? Or short of subpoena timeframes, do you have in place any either deadlines or communications with the auditee on by when they should respond?
We do. When we send out the initial contact letter, it has a deadline indicated in there, which is 30 days. Somewhere around the 30-day mark, if we haven't received anything, the auditor will go ahead and contact the auditee and say, just following up on this request, just checking where you are, if you have any questions. If you haven't still received the documents, 5 days later, they will follow up again. And then if we still don't get anything, then we follow up with the subpoena if requested.
If you, over the experience that you're going to continue to develop with the team, start to find that it's helpful to have any additional authority, either regulatory or otherwise, to put deadlines on that back and forth. There's that initial 30 days, but then it sounds like it gets pretty informal at that point till you get up to a subpoena. I'm sure you would bring that back to the commission if you felt like it was necessary for us to do anything to help with that timeframe. But I'll always be interested in hearing that. Whatever we can do to nudge within reasonable timeframes the respondents to cut down on that back and forth. Some of it might just be, look, we got a lot of stuff to give you, but other might be, I don't really want to pay attention. So if we can help with that, we'd like to.
No,
Thanks.
that's a great point. Thank you.
Even if it's statutory or whatever. Whatever we can do within our authority that's appropriate. Thanks.
So continuing with the audit findings, our education and training team has also always emphasized the proper record keeping and the importance of maintaining these records. And these are also listed in our campaign disclosure manual, which is available on our website for all candidates or anyone who is interested in reading them. So as mentioned earlier, material findings are included in our audit report with an explanation for the finding from the candidate or the professional rep or treasurer. And then these are sent over to the enforcement division. Determination of whether further action is needed regarding an audit finding is generally done by the enforcement division. So like I said before, once we send our audit reports over to enforcement, we consider it closed on our side, and then they take care of any further actions if needed. But that assessment is done by enforcement, so we have no say in that. And then, so this concludes my presentation. I will be happy to answer any additional questions you may have.
Thank you, Chief Shaw. I appreciate the presentation. Do commissioners have particular questions for Chief Shaw? Commissioner Wood, anything?
I really enjoyed it. I've studied some of the FEC audits that they did in the 70s, and a lot of what you said sounds a lot like what they did and what the kinds of findings that they had most commonly also. And so it's interesting to me that there's not that much difference at the state level. I don't know. I just have like kind of small, more precise data questions that maybe would be good to just talk to you about separately. But in general, I just wonder if you find that, incumbents are less likely to have violations and things like that just because they're less new to the process. But I don't know if you could answer that sort of thing just sitting here today,
Yeah, I can definitely look into that. I'm not sure if I can answer those right now, but yeah.
It's a curiosity question. Yeah. That's all.
We can definitely discuss offline if needed. Yeah.
Yeah, sure. Thanks for your good work.
Thank you.
So I did have one question. As you're identifying, in one of your slides talks about this, you identified various trends in the types of findings that occur in the audit. Kind of similar to what I was asking Ms. Brouwer with respect to email advice. Are you sharing that with colleagues in other departments, particularly like education and outreach, to perhaps change, add to, clarify things that may be in those manuals that are being used by stakeholders?
We are. We have previously shared these trends. If anything we have noted that we think is a trend or something new that's happening that we have never seen before, we definitely consult with PREP. And I know Luz, our supervising management auditor, has reached out to them in the past, even before I have been here. So we're definitely reaching out to our education team. We make sure they emphasize these. When we talk to our auditees even, we tell them, for the future, just FYI, you should be doing this or that. And then we refer them to the guidelines that are out there for them.
All right, I appreciate that. Again, let me just say, I think you're doing a great job. I really appreciate the things you've done to improve the efficiency of the audit process. We're already seeing results from that, and so appreciate your efforts. Great job.
Thank you.
Yeah. All right, before you go,
Yes.
Is there any public comment on item 12? Hearing and seeing none. Thank you, Chief Shaw.
All right, thank you.
All right, let's go ahead and move along to our next item then. It's our legislative update, and we'll welcome to the table our senior FPPC Legislative Counsel, Ms. Nakano. I see we're getting close, Ms. Nakano. Your report says September 14th is the last day for the houses to pass the bills, so we're coming up to the end here.
We're in the home stretch.
Yes.
All right. So today I'll go over the updates for all commission-related bills. I'll also ask the commission for a position vote on two bills, AB 868, which was amended and which I'll go over in detail shortly, and a new bill, SB 569, relating to lobbying audits. I'll start with the commission-initiated bills. AB 868 by Assemblymember Wilson, which would create a public record of digital campaign ads, was amended on June 27th. These amendments do make substantive changes, which is why after discussion, I'll ask the commission if it would like to reaffirm its support and sponsorship of the bill. The recent amendments make three notable changes. First and most significant is that the bill partially alters who is responsible for submitting copies of digital ads and information about them to the commission for inclusion in the public record. Before these amendments, the bill would have made committees solely responsible for making submissions to the public record. The recent amendments instead take a bifurcated approach, requiring online platforms to transfer to the commission the ads that appear on those platforms and requiring committees to submit other kinds of digital ads. Online platforms under existing law are already required to maintain publicly available records of the digital ads that appear on their platforms. AB 868 would alter their existing duty to require platforms to transmit that information to the commission rather than maintain their own records publicly. There are two more changes made by these amendments. Committees would only be required to submit their digital ads to the commission if they reach $1,000 or more in digital ad spending within a campaign statement reporting period. And last, the amendments add advertisements displayed on connected TV platforms to those that would be included in the commission's public digital ad record. A connected TV is basically an internet-connected television. Connected TV platforms are the streaming services on your connected TV like Hulu, Peacock, Disney+, those kinds of things. With that, I'll turn to the commission for any questions or discussion. And following that, the commission may vote on whether to reaffirm its position.
Thank you, Mr. Kano. Let me begin by, we have an ex parte contact disclosure policy, and so I will disclose that since our last meeting, I have had conversations with representatives of the California Clean Money campaign. They were the group that primarily advocated for the amendments to this bill. So I appreciated their engagement and certainly understand their perspective. And from my perspective, I think that the bifurcated approach here is a good one. It's a manageable one, and it's a fine place for us to start in this effort, which ultimately really is designed to create one place where the voters and the public can go and see the digital campaign ads and have an understanding of who's trying to persuade them to vote one way or the other. So I think the primary mission and purpose of the bill is maintained even with the bifurcated approach. So I'm in favor of continuing to support this bill. But let me turn it over to my colleagues. Commissioner Baker.
Thank you, and thank you for the update and the report. I have a few questions. You include in the memo the Senate votes. Do you happen to recall what the vote was? It doesn't even need to be precise, but in the Assembly, has there been bipartisan, if not co-authors, support for the legislation? I believe that's what I'm seeing from the Senate votes. When you see a 10-1 and a 6-1, maybe somebody voted no, but either by remembering what the Assembly vote was or your experience with this in general, has there been bipartisan support for the bill so far, and certainly in its current form? And probably hasn't been votes on it in its current form if this happened over the recess.
I think that's correct. It
Yeah.
was amended in the Senate, so we wouldn't have the Assembly's perspective on the recent amendments.
And, I could have looked this up myself, so I'm sorry to put you on the spot for that. It's kind of my regular point. I like us to support bills that have gathered bipartisan support and reached compromise. And I've in the past often abstained on this bill, both in the last term and this one, for particular provisions that didn't set well with me, but I am pleased with where this has landed, including that the disclosure that has to happen on the part of the committee isn't how they targeted the ad, which I think is proprietary information that we should not be requiring campaigns to do. We are saying how much money was spent on it, but they're going to have to disclose that kind of in their expenditure reports anyway. So I think that is good. And so I think I'm there, but that bipartisan question is important to me. And the second is, are you aware of any opposition on record that still remains to the bill in its current form?
To my knowledge, TechNet, which represents platforms, was in opposition, as I heard recently.
Okay, to the bill in its current form. Do you know if that's in their current form?
I don't think that they have retracted their opposition.
Gotcha. So they opposed before it was amended this way, and they haven't retracted it. Gotcha. Okay. And then, so those are my two primary questions, was has there been bipartisan support for the bill, if not co-authors, because I see only one listed, but perhaps there are other co-authors that sort of next level of authorship, and have there been bipartisan votes for the bill up to this point?
No bipartisan co-authors at this point. Reviewing the votes, it does not appear that we've had bipartisan votes on the bill.
Okay. Well, that's too bad, but
Sorry, can I ask? No, I'm confused, because I thought when we looked at the Senate votes, they were bipartisan. Did I misunderstand that?
Well, I'm just seeing 10-1. I don't know if that committee only had one minority party member on it, but when I see only one vote no, I haven't looked at the composition of the committees, so I guess that would be a question for Senior Counsel Nakano. And if you have to come back to it, and I apologize, should have given you a heads up on that in advance, you'd have that more at your fingertips, or found it out myself, because that should be in some record somewhere. I am prepared to support this because I do think it reaches a better compromise. I will say this, that if this becomes law in its current form, and it is, we have some practice with it in the coming years, we may be off the commission by that point, but if we start to find in the workload that our enforcement team has, that there are many cases that are coming forward as, they missed the 24-hour report on this or otherwise, that perhaps is small public harm, but we're starting to see a volume increase. I hope the commission will invite a report back at that time, because that was one of the areas that in the past I've been concerned about, is the committees will have one more deadline that they can miss inadvertently as opposed to major public harm. And it either hits our workload on the enforcement side, or it's just kind of hitting a committee and a candidate for what could end up being a difference between filing at 24 hours or 72, minor public harm issues. I hope that the commission in the future, whoever's on it, will watch the trends on this bill as it applies to either complaints or enforcement issues, because that is important to see. Thank you.
And I'd like to make a correction. There was a bipartisan vote in the most recent committee, the Senate Judiciary Committee. There was one Republican vote.
Well, there you go. Thank you.
Thank you for the reminder.
All right. Any other commissioners have a comment on this bill? Commissioner Wood, I'm curious, do you have any comments? I know you were my partner in crime on the Digital Transparency Task Force.
I continue to think that targeting is important, and that there's a difference between the information we get when somebody advertises like on broadcast versus on social media and all that. But that said, I think that this is workable and this is doable, and that we will be a leading state in this issue and that we should go ahead and support it. And I think that there's room for improvement going forward, and we'll learn from experience. And so I'm still in support, and I appreciate all the work that you've done on it.
All right. Any other commissioner comments on 868? All right. Hearing and seeing none, I will make a motion that we continue to support Assembly Bill 868. Do I have a second?
I can second.
All right. Let me call for public comment. Is there any public comment on our vote to continue supporting Assembly Bill 868? Hearing and seeing none. Ms. Contreras, please call the roll.
Commissioner
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
Motion passes.
Excellent. Thank you. All right. Ms. Nakano, back to you.
Thank you. Moving on, next bill is SB 29 by Senator Glazer. This relates to the Commission's Political Reform Education Program. And that bill was amended June 22nd. These are more minor amendments requested by the Assembly Elections Committee to clarify that if a person successfully completes prep, they're not subject to any kind of enforcement action under the PRA for that same violation, which is consistent with our current policies. The bill was heard in the Assembly Appropriations Committee yesterday. It is on suspense due to its costs. While the Commission itself no longer has costs on the bill, as the requested positions were approved in the 23-24 budget, SOS requested 2 new positions in relation to the provisions allowing waiver of the late filing fee under certain conditions. SB 678 by Senator Umberg, requiring disclaimers on, yes?
Sorry, can you just expand on that for a moment? I'm curious why SOS, why they think they need 2 new positions on this one.
I don't have the full analysis, only what was in the Appropriations Committee's analysis. They anticipated, according to that, their statement, 2,000 new waiver requests as a result of the waiver provisions in SB 29.
Aren't they already processing waivers?
It's staff's understanding, given SOS's current policies on waiver, that there is a lot of overlap between what the bill allows and what their current policy allows. For example, they have a waiver, they allow waiver for certain medical conditions and illness. And additionally, they currently receive waiver requests for enforcement actions that go through the Commission's Streamline program. And as you know, individuals who qualify for PrEP would otherwise go through the Streamline program. So those numbers should be pretty consistent and shouldn't be too much affected by the bill. So from our staff's perspective, we're unsure of where that increase is coming from, but that was reported by SOS.
All right. Well, if you uncover a rationale for that, I'm sure the Commission would love to hear it at the next meeting. Thank you.
All right, moving on to 678. This is by Senator Umberg, requiring disclaimers on third-party social media posts. This is back in the Senate for a concurrence vote, so that bill is moving along. Move on to other Commission-related bills. Before I get into all of these bills, I wanted to note that there are 3 new bills that now amend the Political Reform Act. 2 of them are noted in the written report. One of them was just amended this week, but I will go over all of them, including the newest one today. I'll go in the order of the written report to keep things a little easier to follow. That brings us to AB 37 by Assemblymember Bonta. This bill expands the permitted use of campaign funds for security expenses. I'm happy to report that the bill was amended consistent with feedback from the Commission. I want to thank the Assemblymember and her staff for working with us on this. The amendments add a reimbursement provision. Specifically, a security system purchased with campaign funds for any party must be returned, or reimbursement must be paid for the system at fair market value. The deadline for return or reimbursement is for an elected elected officer within 1 year of the elected officer leaving the office for which the system was purchased, or upon sale of the property, whichever is sooner, or for a candidate within 1 year of the candidate no longer being a candidate for the office for which the system was purchased, or upon sale of the property, whichever is sooner. So in short, the deadline is within 1 year of no longer being an officer or candidate, or when the property is sold. Because security systems can be purchased for the elected officer or their staff or their immediate family, the bill also addresses the question of who is ultimately responsible for paying reimbursement. Immediate family or staff would not be personally liable for reimbursement. They may pay for the reimbursement, but ultimately the responsibility would fall on the officer or candidate. The bill also added back the special reporting provisions and includes a new one. Special reports would be due to the commission when an expenditure is made for security expenses and when reimbursement is paid, and that's the new one. These are separate from and in addition to the regular campaign statements. There are a couple remaining areas where we are seeking clarification, including separate from the security systems, where the quote, cost of providing personal security is intended to include only the costs for hiring security personnel, or whether the intent is to allow for the purchase of security-related items as well. And I will keep the commission updated on any future changes there.
Thank you. I'm grateful to you and the author for continuing to work on this and getting it to what is hopefully a good place. I wanted to go back and get clarification. You mentioned that the refund is required of any party. I just wanted to clarify. So staff or family would have to refund, not just the candidate or elected official.
That's correct.
Okay.
Security system for any party, staff, family, or the official or candidate.
Okay, that's different from how I understood it, and I think that is a tremendous improvement. Secondly, on the who pays, just to clarify, the staff or family member can pay that reimbursement, but ultimately the responsibility is on the candidate. So there's a candidate or elected official. So if the staff, for example, doesn't want to or isn't able to, whatever, the candidate is still required to pay. Somebody's got to pay.
Right, correct.
Okay. Well, great. I think that is those are both very good improvements from where we had it before. Thank you.
Yeah. Commissioner Wilson.
I mean, this is hopefully a scenario that wouldn't occur, but let's assume you have a staff person who has a security system. So they'd be required to, well, they could repay for the security system, but if they didn't, it would fall on the elected official.
That's
Is that what, am I interpreting that correctly?
If the person themselves does not either return it or pay reimbursement, then the ultimate responsibility for reimbursement falls on the candidate or the elected officer.
So this could hypothetically be a staff member.
Correct.
So if I'm a staff member and I was terminated and I have a security system, I don't have the resources to repay the, I could argue that I don't have the resources to pay for the security system. Okay, thank you.
I have no questions. Commissioner Wood, do you have any questions on this one? All right.
All right, thank you. The next bill is AB 334 by Assemblymember Rubio. This relates to Section 1090 and independent contractors. Just a status update, that bill's on the Senate floor on the consent calendar, so that one is also moving along. The first new bill I'll talk about today is the one that is not in the written report. It's AB 421 by Assemblymember Bryan. The bill previously amended only the Elections Code, but was amended this week to also amend the Political Reform Act, and it relates to ballot pamphlet summaries. Specifically, the bill would require the official summary for a referendum measure prepared by the Attorney General to include top funder information in a certain format. It also requires SOS to determine the list of top funders no later than the date that the referendum qualifies for the ballot.
I have a question.
Mm-hmm.
So it's a snapshot of the top funders at a particular moment in time. Is that right? For purposes of the ballot pamphlet materials?
Yes.
But then, assuming this became law, the advertisements for that same measure would have different top funders, presumably, as they change over time. Because we know top funding is a kind of an iterative thing.
Right. I think you're correct that it is a snapshot in time of the top funders at that particular date or time.
Has the author considered the potential for confusion or generating a bunch of well-intended but perhaps not accurate complaints when somebody sees top funders in the ballot pamphlet and then they receive an advertisement with a different set of top funders?
I don't know that that topic has been brought up in committee discussion or otherwise, but I can bring that to the attention of the author's office.
I think you might want to. I mean, it just kind of strikes me. I hadn't thought about it, honestly. I know you you sent an email about it the other day. I hadn't thought about that being a consequence, but it is if you're, because of the way the ballot pamphlet materials are done, you have to fix what you put in there at a certain point in time, and the top funding changes over time, and the committee's obligations to constantly update it is in the law. So there's gonna, I think, be a strong likelihood of a disconnect between those things, and it could be confusing.
Yeah, because I think that pamphlet is quite farther in it, when they have to go to publish and the deadline for what they put in there, it's quite ahead of actually when the biggest spending on a campaign happens.
August
Yeah.
before November elections, so I mean, they haven't gotten going really.
Thank you for raising that and
Yeah.
for sharing it with the author in hopes that they'll work on that.
I will connect with the author's office on that point. Thank you. All right, next bill, SB 24 by Senator Umberg. This is also a status update. This bill relates to public financing of campaigns. This was referred to the Assembly Appropriations Committee, but I have not yet seen it set for hearing. Both SB 248 and SB 409 by Senator Newman are on the suspense file in the Assembly Appropriations Committee. SB 328 by Senator Dodd will be heard in the Assembly Appropriations Committee next week. It's also expected to be placed on the suspense file due to its costs. On to the second new bill of the day. This is SB 569 by Senator Glazer, which previously related to another subject but was amended to transfer the lobbying audit duty in the Political Reform Act from the Franchise Tax Board to the FPPC. This is an issue that has been on the Commission's radar for quite a while. As you might recall, in March of this year, the Senate Elections Committee held an oversight hearing on the status of lobbying audits required to be conducted under the Act. Due to insufficient resources, FTB has been unable to complete most of the required lobbying audits over the last several audit periods. As we stated in the oversight hearing in March, FPPC staff see these audits as crucial for transparency and accountability. Audits operate to monitor compliance with the PRA and are the main and most consistent vehicles for discovering lobbying violations. Under the bill, the Commission would be responsible for the mandatory lobbying audits, starting with the audit selected in February of 2025, covering activity in 2023 and 2024. The bill would exempt from the initial selection pool those lobbying entities with less than $1 in activity. The bill would additionally require the Commission to publicly post all audits completed by the Commission on its website. It would require the Commission to report annually to the Legislature on the number and type of audits completed, and would require the Commission to adopt regulations or policies to ensure the operational independence of audit personnel from enforcement operations under the Act. Taking on these audits would create a significant workload increase in the audit division, and we have worked closely with staff to determine a realistic estimate of positions needed to complete this workload. To implement the bill, the Commission would request 9 new positions in the audit division. Senator Glazer's office has requested Commission support on this bill, so I'll pause here for any questions or discussion.
Well, let me just say, I appreciate Senator Glazer's continued attention to this issue. I mean, this is something that the Commission has been talking about for years, and unfortunately, I think this is the way to solve the problem ultimately. I think we have the expertise. There's no question about that. The only question is resources and the fiscal impact to our agency. I mean, I would just say, I know we worked very hard with Chief Shaw to make sure that the fiscal impact in here was accurate and that she felt comfortable with it. And as long as she's comfortable with it, you know, I'm willing to suggest to everyone here that we offer our support to SB 569.
Yeah, I agree, and I move to approve for those reasons, or support.
Second.
All right, we have a motion and a second. Commissioner Wood, do you have any comments?
I don't.
All right. Is there any public comment? We have a motion and a second to support Senate Bill 569. Hearing and seeing no public comment, Ms. Contreras, please call the roll.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, very good. Please continue, Ms. Stefano.
Thank you. Our next bill is SB 632 by Senator Caballero. This is the third new bill today. It relates also to candidate ballot pamphlet statements. The bill requires the Office of the Elections Official and the Secretary of State's office to notify a candidate of whether their statement was approved or rejected within 1 business day if the statement was filed electronically, or upon filing if it was filed in person. The bill additionally clarifies that candidates may include party affiliation and membership or activity in partisan organizations in their ballot pamphlet statement, excluding candidates for superintendent of public instruction, which is a nonpartisan office. Statute is currently silent on whether candidates for partisan office may include party affiliation in their statements. The bill also makes some similar changes in the elections code.
Do you have any information for us on why there's, let me ask, has SOS or anyone else put a fiscal on this? I know we have no fiscal impact on this.
I can pull that up right now.
I think it's great if they let people know within one day, but it's not my understanding that that's their current standard.
The appropriations analysis has not yet been posted, so I don't know what their fiscal effect is. I can contact their office to see if they can share that with us ahead of time, but I don't have that information at this point.
I was just curious what their fiscal impact was. All right, that's all I had. Any other questions on this one? Yeah. All right.
Thank you. All right, got two more. SB 681 by Senator Allen shortens the time that PRA bills must be in print before final voting. Status vote on this one. It passed in the Assembly Appropriations Committee yesterday and is now on the Assembly floor. And last, SB 724 by Senator Glazer, requiring a new report for certain paid communications that identify elected state officers, will be heard in the Assembly Appropriations Committee next week. And that concludes my update. Happy to take any questions.
All right. Commissioner Baker?
It doesn't appear that the author, Senator Glazer, has asked for a support on SB 724. This is one, I've been watching because I do think it is really necessary. Normally, I don't know if we always wait for the author to do it, but for my part, and I'm springing this on my colleagues without much warning, I would support this bill. I think it is a good bill. I think bringing some more transparency for sure to communications that go to voters within the time frame that, mention someone and get really close to what we kind of were finding a problem earlier today, hours ago, which is, something crosses the line and you're almost advocating. This kind of reminds me of that. So I won't make the motion because I'm springing it on my colleagues without much warning, but this is one that I would like to see us support.
Yeah, I agree. I'm sorry. Commissioner Wood, you go.
I just have a clarifying question. It seems to me that it's expanding the length of the electioneering communications window. Is it doing anything else? I've always thought the electioneering communications window should be expanded in the age of online advertising that can just persist forever. But I'm not familiar enough with our, like discrete thresholds and things like that to know whether it's doing anything else. So I'm just curious as to whether I'm right to interpret it as doing what I just said.
It is a separate reporting requirement from the existing requirement, so that the electioneering reporting requirement in law is retained intact. This is an additional new reporting requirement, somewhat different, but similar also.
Okay.
It has lower thresholds. The time frame is longer, so it captures a longer period of activity, a lower threshold of activity. Aren't those like essentially the main improvements that this law
Yes, I think that one of the main differences is the existing law applies to candidates. This one applies to sitting officials. So a little bit different in that way, but it is a wider window, lower thresholds, captures more activity.
Okay.
Is there any registered opposition to this bill?
I can pull that up as well. As of the most recent analysis, committee analysis, there is no opposition on file.
I agree with Commissioner Baker. I think this is a worthy bill that we should support, and so.
Well, I move to support the legislation.
I will second. Do we have any public comment on our motion to support Senate Bill 724? Hearing and seeing none. Ms. Contreras, please call the roll.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
All right. That's a good one.
Nothing else for me.
All right, any final questions, comments for Ms. Nakano on her legislative report? All right, any final public comment on item 13? This is our legislative update. Hearing and seeing none. Thank you, Ms. Nakano.
Thank you.
All right, we'll move now to item 14, our executive staff reports. We'll begin with the Enforcement Division report, and we have Acting Chief Burton back with us. Acting Chief Burton, did you have anything that you wanted to draw our attention to?
Thank you. As the chair noted earlier, this month's report includes the latest quarterly update for our case data, which does show the progress that we've made over the last 4 quarters, bringing cases down. I do want to commend the enforcement staff for the great work they've been doing to get those numbers down. On that note, I also want to mention that at next month's meeting in September, we will be providing an update to the commission on enforcement's progress towards the meeting the policy directive goals as adopted at the January meeting. And so look forward to giving you that report as well. Other than that, the report is as submitted.
All right, thank you. I mean, I would just echo again your quarterly numbers. These are very reassuring that the Enforcement Division has a concerted, focused effort to get through those old cases. So I certainly appreciate, I think the commission appreciates seeing the focus in that area. So good work over the last year on that.
Thank you.
Questions or comments from Mr. Burton? All right, thank you. All right, up next, Chief Shaw, the Audit Division report. Anything you wish to bring to our attention in your report?
No, my report is as submitted, but happy to answer any questions.
All right, thank you, Chief Shaw. Any questions for Chief Shaw?
I just had one. So you've got here a item number B2, the Galgiani for State Board of Equalization. Now that these things have been identified, of course, you just gave us a report on how things go. What do you anticipate happens next with that matter? Or
We
is there-
have submitted our report over to the Enforcement Division, so.
It's up to them because they're
It's up to them
independent.
now. Yes.
Okay, got
We
it.
do
That
not-
was just to close the loop on that this has been
Yes.
sent over to enforcement for them to do
Yes.
what they, in their judgment, think is appropriate. Okay, thank you.
All right, thank you, Chief Shaw.
Thank you.
All right, up next, Legal Division report, Mr. Bainbridge.
Just a couple quick items. Under pending litigation, we have the Family Business Association of California v. FPPC. That was the Superior Court case challenging the changes made to Government Code 84308 by SB 1439 last year. The law was upheld at the Superior Court level, Sacramento Superior Court. The deadline to file an appeal was on Monday, and we have not received any notice or copy of an appeal being filed, so I'm assuming it was not filed. I guess the mail could be slow, but I think that case will be going away, and the Superior Court judgment will be the final decision on that one.
That's good news.
Let's see. Speaking of 84308, you'll see under new and updated educational resources, we've put up a web page specifically dedicated to information about 84308 and the pay-to-play provisions. We're also working on updating pamphlets, or not updating, creating new pamphlets that are a comprehensive treatment of the requirements of 84308. The plan is to make one that's aimed towards officials to review, and so they can understand their requirements, and then have a separate one that's aimed towards parties and participants. We think separating that out will make it a little more digestible for the different parties based on what their interest is. So we'll hopefully have those done in the next month or two, and put them up on the website once they're ready to go, and I'll share those with the commission when they are complete. We're also working on a training that we're going to, once that's done, push that out to the public and offer up webinars that people can participate in. We've been getting requests for a training on that, so we are working on it. We're putting it together. We wanted to get the written materials done first, and then we'll do the webinar training. And then the last thing to mention is that we have some staff, Chloe Hackert, who's our head of education, and then Shraddha Shah, and then also Angela Brereton of enforcement, will be presenting to the California Political Treasurers Association tomorrow, providing them information about our educational efforts and then giving them an opportunity to ask questions about the enforcement process as well as the audit process. That's all I have for this month.
All right. Thank you, Mr. Bainbridge. Commissioner Baker?
Yep, thank you for the report. Just two questions. Under item D, where you mentioned the PrEP program, there was a mention that one learner was withdrawn from PrEP because we determined that they did not violate the act. A little bit unusual to see that. I'm just kind of curious how that transpired, and if you can share that. How somebody gets in PrEP before it's been determined that they didn't violate the act. I'm sure there's a perfectly normal reason.
Yeah, I'm trying to remember the specifics. I believe what happened was the referral was wrong in some way.
Okay.
And so once we got them and started looking at it, we realized that the document had been filed timely.
Okay, got it. Thank you. And then on item E, with respect to the advice letter report, I don't remember, it was the June, probably July advice letters. I noticed one of the first ones in there was about strong mayor and the pay-to-play bill that we had. I'm trying to jar my memory from our last meeting in June. Was there going to be a subsequent follow-up with the commission on the strong mayor issue with respect to pay-to-play? And can you update us on that?
The commission had asked that I come back and provide an update on advice that had been given. I think we decided on a quarterly basis, if I remember that correctly. So September or October, I'll come back and provide an update on any relevant advice we've given on 84308.
Thank you. And just note, there is an advice letter already issued out, so thank you.
All right. Any other questions, comments for Mr. Bainbridge? Hearing and seeing none. Thank you, Mr. Bainbridge. Chief Hahn, Administrative and Technology Division report. Anything you wish to highlight?
I would just like to point out a typo that we did with our new enforcement chief. Unfortunately, his last name is with an A rather than an E on Lindsay. I just want to point that out.
It's unfortunate there's a typo. His last name is spelled however it is.
It's unfortunate, my typo. And then there's one additional point that I wanted to bring to your attention that's not part of my report, is that we have confirmed our October commission meeting with California State Fresno University that will be hosting our commission meeting in October at their location.
Very good. All right, Commissioner Baker.
This may or may not be the right place. Since we're going to be at Cal State Fresno, and thank you, Cal State Fresno, out there for hosting us, if there's any time for outreach to some of their poli-sci or government classes or otherwise, and that to let them know and invite them. It's exciting to come to an FPPC meeting, especially in person, and since we're at an educational institution, if it doesn't take a lot of staff time to do that outreach, I'd be all down with that, and we'll see if anybody takes us up on the offer.
Yeah, that's a good idea.
I think Commissioner Baker, it's a good idea, but we'll probably need additional seating because I'm expecting a full house in Fresno.
There's thousands of people watching this meeting, according to your earlier comment.
Actually, I think our comms director have something to update about that later after my items. Thank you.
Thank you. Thank you, Chief Hahn. Commissioner Wood, anything for Chief Hahn before we let her go? Yes, Commissioner Wood?
Sorry. I was looking for the mute button. If I need to be helpful on the political science side of things, I would be happy to. So just keep that in mind. Of course, I guess we're going to hear from somebody next about that. So.
All right. Thank you, Commissioner Wood. All right. Thank you, Ms. Hahn. Executive Director West.
Yes, as alluded to, Press Director, Master of Communications, as he's making his way to the table, is going to give us an update on some of the educational items that we've been doing lately to help our staff and keep up with technology.
Thank you, Ms. West. Chair and Commissioners, good afternoon. Jay Waringa, Director of Communications. Speaking of that, last week at this time, this room was filled with 15 staff from the IT and the education unit as we took part in Adobe Pro video training that was provided by Professor Steve Schlisky, who we have been working with. He's co-chair of the media department at Laney Community College in Oakland. We felt this would be valuable for our team, especially the education unit, to come up with videos to go along with a lot of the educational materials that will be put out through prep and everything else. It was valuable training for IT to keep up with the latest technology, and I hope I took a few tidbits myself for our own videos moving forward. Speaking of which, we are currently working with Professor Schlisky to recruit another candidate, a student candidate, for a video this semester. And with that, we do have a video that is almost done from the last semester, which we will be presenting next month along with Professor Schlisky. Elizabeth Baker has been working on a video for us, and hopefully we will have a presentation for that in September. And to follow up on Ms. Hahn's note, we will be having our video, our conference, our commission meeting also broadcast by the Maddie Institute and CSU Fresno, as well as our own video. That is something that they are going to do, and then we will have a follow-up interview with the chair afterwards for the Maddie Institute, which also has a program that runs for about a month and a half afterwards, which gets a few 100,000 views every month. So we will hopefully be getting some impact out of being in Fresno. And with that, any questions?
No, I think that sounds great. Appreciate your efforts. Sorry, Ms. Contreras, did we drop the call? Okay. So what is that?
We have to call again, and we have to redo the whole presentation. Just this part.
Are we still live on YouTube?
Yeah, we're still live on YouTube. It's just.
So it's just the public comment line that is dropped? Okay. All right. Well, why don't we go ahead and finish Jay's item, and then we'll make sure to call for final public comment at the end after it's rebooted.
That's my report.
Any questions or comments for Mr. Wierenga?
All right.
All right. Thank you very much. Executive Director West, do you have anything additional? All right. Thank you. All right. Brings us to our last item, commissioner comments, proposed future agenda items. Do any commissioners wish to offer suggestions or comments for future agenda items? Going once, going twice. All right. Is there any final public comment before we adjourn? Well, the digital public comment is still up. So at this point, I'll go ahead and entertain a motion to adjourn.
Welcome to AT&T's teleconference service. Please enter your access code, followed by the pound sign.
I'm going to move to adjourn. Do I have a second?
Second.
Second. Ms. Contreras?
Commissioner Baker?
To join the conference as the host, please enter your host password, followed by the pound sign.
Aye.
Commissioner Woodson?
Aye.
Commissioner Wood?
Aye.
There are 1 participants on the call, including you.
She said
You are
aye.
joining your conference as the host for
Chair Madich?
Aye.
Yeah. Motion passes.
All right. Thank you, everyone. We will see you in September. And apologies for the technical difficulties this month. See you guys next month.
Bye.